you're ready. Everyone, reminder, please keep your microphones muted. The next voice we'll hear will be the voice of Justice Renwick. Have a good afternoon.
You're muted.
I'm aware, thanks. Good afternoon, everyone. The Appellate Division First Department is now in session. Welcome to our department's virtual argument session. I'm going to begin by calling the calendar. People versus Michael Curry for the appellant.
Good afternoon, Your Honor. I'm Stephen Moralia for appellant Michael Curry.
6 and 1 for the respondent.
Yes, thank you.
Good afternoon, Your Honor. This is Sheila Bautista for the people.
5 minutes.
Thank you.
Diaz versus Vivar Martinez is submitted. And Griselda versus Yvette C. is submitted. James versus Kensington Associates for the appellant.
Yeah, Natasha Berg of Hack and Rose for the appellant.
5 and 1 for the respondent.
Good afternoon, Your Honor. Stephen Strauss for the respondent.
5 minutes. Prados versus the City of New York for the appellant.
Brian Isaac for the appellant, Your Honor.
5 and 1 for the respondent.
Yes, Michael Caro from London Fisher for the respondent, Your Honor.
5 minutes.
Thank you.
Wimbledon Financing versus Canton Region for the appellant.
Michelle Rice, Kaplan Rice for Wimbledon Financing.
6 and 2 for the respondent.
Yes. 6 and 2 for the appellant. Yes.
6 and 2 for you. Yes. For the respondent. Mr. Peretz. Is the respondent here? Okay, I'll come back to it.
I believe he is here.
Yes.
But he's
back to it. Thank you. Schwenger versus Mittman for the appellant. I'm sorry, that's submitted. Bay versus Rosado for the appellant.
Good afternoon, Your Honor. Yolanda Ayala for the appellant.
3 and 1 for the respondent.
Yes, hello, good afternoon. Joshua Versosa from Liakis Law for a respondent.
3 minutes. Aspen Specialty versus RLI Insurance for the appellant.
Good afternoon, Your Honor. Joseph D'Ambrosio for the appellant, RLI Insurance.
6 and 2 for the respondent.
Good afternoon, Your Honor. Scott Rader of Mintz Levin for the respondent. 6
minutes. People versus Jesus Arias is submitted. Moses versus Dunlop is submitted. Torres versus Louisiana Inc. is submitted. Cruz versus Sharkey's Trucking for the appellant.
Good afternoon, Your Honor. John Shaw from Grave and Associates for the appellant.
5 and 1 for the respondent.
Good afternoon, Your Honor. Peter Reed from Marshall Dennehy, Warner Coleman and Goggin for the respondents, Sharkies, Marlon Rivera, and Katzman Produce.
5 minutes.
Thank you.
People versus Olivo Gomez is submitted. U.S. Bank versus Kim for the appellant.
Good afternoon, Your Honor. Robert Pollack from Parker, Ibrahim, and Berg for the appellant.
6 and 2.
Thank you.
For the respondent.
Good afternoon, Your Honor. Christopher Volante for respondent, Robert L. Gordon's LLC.
6 minutes. Verma versus Department of Education for the appellant.
Good afternoon, Your Honor. Daniel Dugan for the appellant, Yuvraj Verma.
5 and 1 for the respondent.
Good afternoon, Your Honor. Anna Gottlieb from the New York City Law Department for respondents.
5 minutes. People versus Lamont Jackson is submitted. Camera Supplies versus Geico for the appellant.
Good afternoon, Your Honor. Stephan Belinfanti from Gary Searleman PC.
5 and 1. For the respondent. For the respondent.
Hello.
Yes.
Hi, good afternoon, Your Honor. Lauren Hirschfeld with the law offices of Goldstein, Flecker, and Hopkins for the respondent.
5 minutes. Silbowitz Garafola versus Paravas is submitted. Sullivan versus Snow is submitted. Immigrant Bank versus Rosa Bianca is submitted. I'm going to recall number 6, which is Wimbledon Financing versus Canton Mutual. I already heard from the appellant. Is Mr. Peretz here now?
I am here. Can you hear me?
Oh, okay. And it's 6 minutes for you, okay?
Thank you very much, Your Honor.
Okay. Counsel, please remember, as always, that we have your briefs, we have your record, and we're fully familiar with the facts of your cases. So please go.
Hello? Hello?
So that please don't speak when a justice is speaking, so that we can make sure we hear each other's questions and you hear the court's questions. And finally, keep your mics muted, and hopefully you'll remember to turn them back on, but keep them muted unless you are speaking. Thanks very much. First case for argument is People versus Michael Curry.
Good afternoon, and may it please the court. In this case, appellant was convicted of, among other things, bribing a witness. Specifically, that in a series of phone calls that he made from Rikers Island to the complainant, his girlfriend or ex-girlfriend, he offered to confer a benefit to her with the understanding that it would influence her testimony in a pending criminal proceeding against him. And those proceedings in question were stemmed from his having been indicted for sexually assaulting her. And in the calls, appellant urged the complainant to drop the charges and to do what she had to do to get the case dismissed. But throughout the discussion was the understanding that both the complainant and appellant shared that the incident in question, the sexual assault in question, wasn't a crime. This was because they had this belief, whether mistaken or not, that the conduct as the complaining witness described it to the authorities didn't constitute rape. And in the series of calls, he urged her to be truthful, to say the truth. And she, had told him, I told him that this is what happened. I don't think that this should be charged as a crime, but it's not in my hands to drop the case, to drop the charges. It's beyond my control. So the count of bribery is predicated upon an understanding on the part of appellant that this offer, he was offering to marry her. According to the people, he was saying, if we can't get this resolved, then I'm not going to be able to marry you and take care of you.
Counselor, doesn't that element of marrying satisfy at least the understanding from his part? He thought he was conferring a benefit on her, didn't he?
Well, the offer of marriage could be a benefit, but my argument focuses on whether he understood that it was a benefit for to influence her to testify, to give false testimony, which is of course what the statute is designed to prevent.
And you're saying he couldn't influence her to give false testimony because her testimony was always that it didn't happen? That it
Correct.
was not a rape, that it was consensual?
Yes, and even though that view that they both seem to share may have been a mistake as to what constitutes that crime, it was the understanding that he had. He was just asking her to please tell the truth, tell what happened here, and that with the belief that that would be what would resolve the matter. So there was no understanding on his part that this was going to influence her to give false testimony in a proceeding, just asking her to, tell the authorities what really happened here.
Counselor, can you address the criminal contempt?
Yes, so there were two charges of criminal contempt. The first one was for a series of actions that appellant took, and they both actually stemmed from over 1,000 telephone calls that he placed to the complaining witness while he was at Rikers Island. And in the first one, the charge was that he did this with the intent to place her in fear of physical injury.
Well, but isn't it a fact, Counselor, that your client brutally beat the victim? Her eye, as I recall, was shut for weeks. So wouldn't that put somebody in reasonable fear?
Ordinarily, I would say yes, but if we look at the content of the telephone calls that were recorded and submitted.
This is Judge Gonzalez. What about the fact that there was an order of protection in place barring him from making these calls?
Well, that would go to whether the calls were, whether that element of the crime was met, and yes, it was, but whether he intended by his communicating with her to place her in fear of physical injury.
So I'm sorry, I haven't heard an answer to my question. The beating and the condition she was left in, wouldn't that be sufficient to meet that element?
Your Honor, I would submit that we have to look at the content of the telephone calls, which were all placed, the recorded calls placed in evidence, during which calls they were discussing all sorts of matters. And indeed, she went to visit him on a number of occasions at Rikers Island and brought him things like clothing and stuff like that. So,
but that's not unusual, right? In a domestic violence situation, I mean that's very common. These things occur, correct?
That's absolutely true.
So
yes.
so then going back, with respect to the 1,100 calls, is that sufficient to show intent to harass? 1,100 calls is a lot of calls.
Yes, it is a lot of calls on its face, and some of them were rejected, some of them were accepted. And again, going back to the content of the telephone calls, given that what they were discussing, their relationship, their past problems, their future plans, the need to get therapy, etc., it looked like they were having an ongoing series of conversations. So that my argument is that by placing these calls, continually placing these calls, he wasn't reasonably placing her in fear of physical injury because she was apparently, during at least some of them, engaging with him on topics of mutual concern to their relationship, or what the wreckage of their relationship, I suppose.
But counsel, isn't there a pattern here of physical abuse? 2 incidents in January of 2015, then 2 incidents in February, 3 incidents in February 2015, another incident in March of 2015, another incident in April of 2015. Wasn't there a pattern of physical abuse and then her taking him back on some occasions, to the extent that this could also, the 1,100 calls could be seen as a pattern of intimidation, harassment, annoying her, causing her alarm? Doesn't it fall into those categories?
Yes, Your Honor, it could fall into those categories. But again, given the nature of some of the discussions that were recorded, that we have recordings of, and given the trips out to see him and bring him things, it appeared that she was sort of participating in these discussions and talking about their relationship. At one point, there was a discussion about her getting therapy and suggesting that he do the same, and what their feelings were, and that sort of thing. So it didn't seem like that the content of the calls themselves was inherently threatening or harassing or saying I'm going to hurt you. So that
finish it.
Yeah, so that while ordinarily a series of telephone calls might, provide evidence of the intent that he intended to cause a fear of physical injury, given the content of the calls that we know about, I submit that here it didn't establish that element.
Thank you. Ms. Bautista?
Good afternoon, Your Honor. May it please the court, my name is Sheila Bautista and I represent the respondent in this case. Your Honors, based on the May 28th phone calls, the defendant was convicted of bribery for repeatedly telling the complaining witness to, quote, do what you gotta do to get the rape charges dropped. He told her that she needed to do what you gotta do so I can get you what you need to get. On this date, he told them they had an agreement and an understanding. What's key here is that he told her this even after she had already told prosecutors that she didn't think she had been raped. She told him, I've done and said what I could, and I don't have the power to get the rape charges dropped. Even after she already said, I don't think I've been raped, the prosecutor still brought the charges, and he continued to tell her repeatedly, do what you gotta do. The context of his telling her, do what you gotta do is important. Prior to this date, he had encouraged the victim to mislead the prosecutors by telling the prosecutor that there had been a miscommunication, that she had caught the defendant sleeping with another woman,
Well, wasn't all of that true? Didn't she catch him with another woman? Isn't that why the woman who was in the apartment slapped her?
But it's true that there was another woman in the apartment. However, he told the victim to tell the prosecutors that this is why she wanted to bring the rape charges. He also told the victim.
Wait a second. She didn't want, from the beginning, whether or not there was grounds for a rape or not, she said that she didn't want to bring the rape charges. She said there was no rape. From the beginning, she said there was no rape. So I'm wondering how he could be bribing her about changing testimony that she didn't state in the first place.
Your Honor, it's because she already told the prosecutors that, and after she told the prosecutors, I don't think I've been raped, he told her to do more. He encouraged her to say more. He said, even after the victim said,
he told her to tell the truth. I mean, if you
told her,
counsel, maybe you can't hear me, but I was speaking. So I don't see any words where he told her to say that it wasn't true or to say that it didn't happen. In fact, he said, don't say it didn't happen.
On the date of the bribery, which is May 28th, and Your Honors, I encourage you to look only on that date because that's the date it was charged. He said, do what you gotta do, repeatedly. And this is after she said, I've done what I can. I told them and it wasn't rape. He wanted her to do more. He wanted her to do and say more to get the rape charges dropped.
Isn't that speculation to believe that he wanted her to do more and instead of wanting her to repeat what she already said? He said, do what you got to do. And he had already said to tell the truth. And that's what she said. She said.
And she said she said it didn't work. He said, do what you got to do. That the jury reasonably inferred he's telling her to do more to get the rape charges dropped. And again, this is in the context that prior to this date, he encouraged her to mislead prosecutors by saying that there had been a miscommunication. He told her, tell the prosecutors, don't tell them you've been talking to me. And so I urge the court to look specifically on May 28th.
Well, you're asking us to look specifically at May 28th, but then you're asking us to go back as well. But I think Justice Mazzarelli has a question.
Yes, in a bribery situation, there has to be, at least in the part of the offeror, a belief that he's or she is giving something of benefit. In this instance, what was the benefit that the defendant intended to confer on the complaining witness?
Your Honor, he offered to marry her and take care of her and financially support her. He told her That's the benefit. He said to her,
He said
do
all
what
of
you gotta
that,
do.
or he just said, I'll marry you.
He said, I'll marry you. He said, I'll pay your phone bill. He said, I can help you. You can use my benefit card. He offered to financially support her. He offered to help her look for a job. On May 28th, he says, do what you got to do so I can get you what you need to get. She talked about
But
financial
I'm sorry,
issues.
when did he say the other things about marriage and then about the benefit card? And then, because if you're asking us to look at May 28th, but you keep going back to other dates, I think.
Your Honor, I'm asking to look at May 28th in the context of their prior conversations. On May 28th, he does tell her, do what you need to do so I can get you what you need to get. So those are the words he said on May 28th. And to understand what he means by get you what you need to get, we need to look at their prior conversations about the,
yes,
about
if you
the,
would
sorry.
to my question just for a minute. It's do what you need to do so I can get you what you need to get. Think about that. Use your heart. Go with your heart.
Yes.
Okay.
So their prior conversations provide the context to understanding what he said to her on May 28th. And again, the key to May 28th is the fact that she's already told prosecutors, I don't think I've been raped. And he's still repeatedly telling her, do what you got to do, meaning do what you got to do to get these rape charges dropped. What she's done so far hasn't been enough. He wants her to do more. Based on that,
you're not reading into that what is speculative as opposed to what one can infer.
The jury can reasonably infer it based on the context of their relationship, based on the context of what he's tried to persuade her to do before.
Thank you, Counselor. You have 1 minute, Mr. Carney.
This is Steve Morelia.
I'm sorry, Steve Morelia.
Yeah. Your Honor,
Counsel, did your client ask the victim to contact her lawyers so that she could sign an affidavit and drop all the charges?
Yes. Well, to sign an affidavit, and she then explained to him on the day in question, on the May 28th telephone call, that she went there. She told the same account that she's been repeatedly telling, continuing to say that in her view that didn't constitute a crime, and that she would continue to say that. She would repeat that, and that it was out of her hands as to whether they would be dropped or not. She made that clear, and I think they both understood that during the course of that series of conversations. And he was asking her repeatedly to do what you got to do, meaning apparently to just keep reiterating the same story, which they both believed, whether incorrectly or not, didn't constitute a crime. And I think that going beyond that and sort of speculating about do what you got to do, I don't necessarily think that's supported by the full context of all of those phone calls on the 28th. If you look at what they were saying to each other back and forth.
Thank you. Thank you both.
Thank you.
James versus Kensington Associates. Ms. Berg.
Sorry, I was just finding
okay.
I was just trying to find the unmute button.
It's okay.
Yes, this case concerns two appeals. Both are based upon spoliated evidence of footage surveillance that served as the...
Counselor, when did you get the edited version of the video?
Well, it was actually exchanged in 2015, about a year after his deposition.
So let me stop you there. So 2015, your note of issue was filed in 2018, is that correct?
Yes, we substituted as counsel a matter of months before that.
Well, so in the 3 years before note of issue was filed, why wasn't there a demand made for the raw footage?
Well, the prior attorney was informed at the plaintiff's deposition after it had already started that they had raw footage of the incident, but they did not have any footage of the plaintiff.
That was December 4th, 2014. I thought what they said was that they had raw footage, but none of the raw footage saw plaintiff falling, even though they reviewed it at those times.
That is an incorrect statement, as the transcript itself states that, I'm sorry, just 1 second.
I thought what it said was that defense counsel advised that there was no video footage of plaintiff falling, although there was footage of her walking up and down the stairs without incident, without falling, the day of the alleged incident.
That was not what was alleged. In the deposition transcript at the plaintiff's deposition, verbatim, it states that defense counsel had indicated to prior counsel that there exists no video footage indicating his client fell on the building on the date of question. However, there does exist raw video footage for those days with multiple cameras. And in a subsequent—
Well, that's not inconsistent with what I said, is there? Is that?
I believe it is, as defense counsel had indicated that there is no footage indicating that the client fell, but there does exist raw footage for those days in question.
So counsel, what stopped the plaintiff from reviewing all the raw footage and seeing whether there was some footage showing that the plaintiff fell?
Well, I mean, the raw footage was never exchanged, and the footage itself was not—
Well, but counsel, then it goes to my question, which I never got an answer to. You had 3 years from the time you got the edited film before the note of issue was filed. And when I say you, you know, it's you or your predecessor. I think that's what Justice Gonzalez is getting at. Why in that time didn't you or your predecessor ask for the raw footage, but rather you file your note of issue certifying that all discovery is completed and you're ready for trial? Right.
Well, immediately after we substituted as counsel, we noticed an inspection of the footage itself by an expert videographer who came to the conclusion that that footage itself had been edited and spliced with an editing software. And it was only after we came to that conclusion that we realized that there was never an agreement between outgoing counsel and defense counsel that the footage should have been spliced, or that he
But this was, sorry to stop you, but so this was days, 5 days of footage. The raw video, I think, went over the course of 5 days of footage, where the plaintiff was not in the video every minute of those 5 days. So they cut, and at least this is what they've said, they've cut and put together or spliced only the portions where the plaintiff was, which one would expect.
Which is also incorrect. At certain times, it depicted a person that was not the plaintiff. The defendant's witness testified that the embedded counter could not be edited and would be consistent. And
counsel, somehow I think we're going in circles. So did you have access to the footage? And Judge Singh's question remains, couldn't you have demanded, if you didn't, couldn't you have demanded access to the footage and seen all of the many hours of tape that exist?
It was previously demanded, and prior counsel's demands several times for the footage, not just including the footage that they wish to present at trial, but what was ultimately exchanged was the edited footage that our office received upon substituting about a month prior to the note of issue deadline.
So at the position in December of 2014, there was no offer by the defendants to provide all of the raw footage?
On the record, defense counsel stated that there was raw footage, but they did not possess any footage of the client on the date in question. It does not equate to their contention that they advised defense counsel, or I'm sorry, outgoing counsel, that the footage depicts our client not falling, just that they were not in possession of footage
Thank
of
you.
the incident itself.
Thank
which
you.
in a
Thank you,
subsequent
counsel. You have some rebuttal. I'll let you finish up then. Mr. Strauss?
Thank you, Your Honor. Just on the very last point, the video was offered in full, unedited, before plaintiff's deposition. The plaintiff.
Well, counsel is saying that they weren't counsel at the time, and they asked for it after, and they didn't get it. I think that's what counsel is saying. It was initially, when it was offered in 2014, or whatever date I said earlier, I think December 2014, it was refused. It was the counsel at that time said they didn't need it. So counsel here is saying they came into the case after that and asked for the video, but didn't get it.
I don't believe.
Guess what they got? What they got was the spliced version.
Well, that was produced prior to that time, and there was discussion between the prior lawyer and defense counsel regarding the scope of the footage production. We offered 96 hours, which was a few days before, during, and a few days after, and they didn't. Or we offered the edited, and the edited was selected, and it was mined. It was mined. It was before this, when they got the letter, the preservation letter. My clients got the footage. They know who the plaintiff is. They looked through 96 days of it. They put it all on disk, gave it to their supervisor, and it was stored in a dedicated area at their headquarters. And then when the discussions came back as to what the plaintiff finally wanted, the footage of anything depicting the plaintiff in that time period I was just mentioning, whether she be in or out of the building or on the stairs, was produced. And as all your honors commented and questioned about, there was no complaint about that for 3 years. And there was a motion to preclude for failure to produce it, and that was denied. The plaintiff never
Counsel, this is Judge Singh. Didn't my recollection is there was also I think in 2015 there was a motion made to preclude the video, which was denied as well. Right. Is that correct? And there was no appeal taken of that order?
There was no appeal taken of that order, and there was no notice of appeal found. And this is, this is the third bite of the apple that they're trying on this spoliation claim, and they're raising authentication issues which were never raised. And this, as I was saying before, this was a prompt and thorough response to the preservation letter, and it was, and two options were provided. You can come look at 96 hours of footage in this time period, or we'll just give you everything that depicts the plaintiff. The latter was selected. That's what we did. Never was there any other effort until after note of issue, and we filed a summary judgment motion. Was there then a spoliation cross motion, which was simply a repackaging of the original motion that was denied and was not appealed. They got everything, and on the facts, the judge's decision really wasn't. Judge Bluth's decision really wasn't based solely on this video. It was based on her testimony, where she changed her story numerous times. It's her story upon admission to treating professionals was, I fell in the street. Her complaint is, I slipped in the building. Her bill of particulars is, I slipped on a wet surface in the building. Her deposition testimony was, I fell, break with the lawyer, come back, I slipped. And there's no more liquid anymore. Now it's a defect. Her story was all over the place, and Judge Bluth focused on that, and that's what her decision was based on. And then she also looked at the video, and the video shows an unbroken gate the entire time, Your Honors. It's the same gate going up the stairs the entire time. And in fact, after she gets to the top of the stairs and proceeds to her apartment, she said in her testimony that she had to get up very slowly, and she had to limp and hop to her building. And the judge reviewed that And that's just not the case. That was an incorrect depiction of what happened. There was no incident, and the judge, that's what the judge held, and it was based on the record.
Thank you. Counsel, you have 1 minute, Ms. Berg.
Yes, well, first of all, the prior motion by prior counsel regarding the preclusion of the video was based on failure to produce, which is a separate issue of spoliation, and it does not preclude a spoliation motion. Furthermore, plaintiff testified as to what made her fall. She specifically identified the defect made her fall. And
counsel, counsel, Mr. Strauss just gave he just went over a number of different ways plaintiff said she fell. She says she fell outside. She said she fell inside. She said she fell on water. She did go through all of that.
She only testified that she fell on the stairs, and when questioned about the medical record that.
But to clarify her fall, she says she never actually, no body part touched the stairs. Only her feet touched the stairs.
She said that her weight fell onto her left side after her right foot slipped. And when questioned about whether she had ever alleged a different event of how the accident happened, specifically the medical record defense counsel was just referring to, she refuted that in her testimony, saying that she had told them that she had fallen on the stairs.
Counsel, she also alleged that she didn't fall, didn't she?
Well, when questioned, she said her weight fell shifted to the other side.
Didn't she ask, when she was asked by the attorney, so did you fall? Did she answer, so define fall?
Right. And I can't assume what was going on in her head, but a slip and fall is just a typical, label for these incidents. And when defense counsel was questioning her, she was clearly confused and was able to identify that her foot slipped, causing her weight to fall onto her other side. She testified that no part of her body did in fact touch the stairs, but her weight fell and shifted onto the leg in which she ultimately claims was injured.
Thank you. Thank you both.
Thank you, Your Honors.
Prados versus City of New York.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant in this matter. I think I have a very simple argument, and I'll try not to go over my time.
Good.
Plaintiff was struck by a falling object. If you read the testimony of Mr. Bowman, who was the superintendent for the general contractor, pages 432 to 433 and 434 to 435, his testimony was that nobody should be working underneath people working above. I think that's the answer to the whole question. If I'm reading the trial court's decision correctly, the trial court was a little concerned with whether or not the incident was caused by an unintentional fall or an intentional fall. I would suggest to the court that your decisions in Albuquerque against City of New York, 188 AD 3D 515, and your earlier decision in Diaz against Rava, that's RAVEH Realty at 182 AD 3D 515.
Counselor, this is Judge Singh. Wasn't the decision also based on this idea that the object that fell wasn't being hoisted or secured? And is that the state of the law? Is that a requirement for a 240 Prens 1 claim?
That has not been the state of the law since, in my view, the Court of Appeals decided Autar and followed it up with Quattrochi. The Narducci decision, as you know, used to be read as saying that if the object isn't being hoisted or being elevated, there was no 240 claim. Court of Appeals rejected that. That is one of the requirements, but the other requirement, and that's specifically in the Albuquerque case and in the Diaz case, is whether or not the object ought to have been secured. You'll recall that in the Autar case, the object that fell wasn't being worked on at all. It was something that was being stored on a dolly. And in this case, not only is it clear that the object ought to have been secured, but the entity that was charged with the overall responsibility for site safety The general contractor specifically said it. The words that he said was, quote, "We try never to put people above," close quote, people who are working. If someone was working above, quote, "you would clear the people below out of the way. And if a person had to work in an elevated position, quote, no workers should work underneath them," 432 to 433. He testified that if he had seen the plaintiff performing work in that manner, he would have told the plaintiff and his co-workers, quote, not to perform that work, 434 to 435. And he even went so far as to say that Perini's safety plan does not allow people to work over people in any, quote, in any case or in any form. It's 437 to 438. So
now,
in that
Mr. Isaacs, I'm sorry, Mr. Isaacs, how do you make out your prima facie case? Because there is, I think it's Mr. DeJesus's deposition has not been signed. Is that correct? So how do you make out? Yeah, and he's really the primary witness. Are you able to make out your prima facie with testimony of plaintiff?
Yes, we can, because the plaintiff testified to the same set of facts, but not with the same specificity. And you actually decided a case that was similar to this, Humphrey against Parkview Fifth. It's 113 AD 3D 558 559. Here's the quote from the case. Quote, "The fact that plaintiff did not see the beam hit the string or know where the beam fell from does not preclude partial summary judgment in his favor, as his testimony demonstrates that the beam came from somewhere above plaintiff and was the proximate cause of his injuries." Justice Singh, I would point out that page 550 to 557, we have an incident report that was authenticated as a business record on 442 to 443, which confirms plaintiff's state of affairs. And I would also point out to the court that on page 559 of the transcript in reply, plaintiff's attorneys pointed out that the rule is actually that an unsigned or unsigned transcript can be used if there is a certification from the court reporter and it's not challenged as being inauthentic. So we would argue that the 240 claim is a perfect claim and that you should grant a summary judgment on that claim. If you have nothing further, I'll stop talking. I'll let my adversary talk. Thanks for listening to me.
Kara?
Yes, how you doing, Your Honor? Good afternoon. Yes, as Justice Singh said, there was no testimony from DeJesus that was admissible, regardless of whether the court reporter.
So let me stop you there, Counselor.
Yeah.
Didn't plaintiff give sufficient testimony that he was struck in the head by an object that was 12 inches long, 5/8 of an inch thick, and it was a piece of rebar?
Well, no, he really didn't. If you looked at his testimony was he was bent over in a position as though you would be tying your shoes, and he was tying a piece of rebar when he felt something hit him. He then looks down and sees rebar on the floor and assumes that that is what hit him. He then says,
I never saw anything in the testimony about him assuming anything. It seemed like this all happened pretty instantaneously. He felt it hit him, he picked it up, and he looked up right away. I think he made a comment to the person above him. In fact, I don't think the person who was with him, and he didn't sign the affidavit, I don't think he saw it. So I don't know why plaintiff's testimony wouldn't be sufficient.
Because he doesn't know what hit him. He doesn't know that Mr. Jennings was even working above him. If you look at his testimony.
But I'm sorry. I recall the plaintiff, after he got hit, he looked up at Jennings and cursed.
He said he cursed at Mr. Jennings. He did not say he knew Jennings was above him when the incident occurred.
So why was your best argument? Counsel, do you have another argument here for this case?
There was no admissible evidence in the motion below. DeJesus's testimony was deemed inadmissible. Bowman's testimony wasn't even used in the motion.
What about the incident report? Wouldn't that come in as a business record? And coupled with plaintiff's testimony, is that sufficient?
No, I don't believe so. I don't believe he put in any admissible evidence to show that this was a 240 case. He did not, just because an object fell. I mean, the courts have been ruling like this for a long time. A falling object is not necessarily 240. And we've also asked, Your Honor, just so that we can get to it before time is up, the 241-6 argument also should be overturned. The arguments were that 23-1.7A1 and 23-1.7A2 were violated. Now, those are contradictory statutes to begin with. First of all, A2 is in places where people pass by but are not required to work. That's clearly is not the case here. In the case here, plaintiff did testify that he was supposed to be working in this mega column at the time. A1 is a place where people are required to work and is normally exposed to falling debris or objects. There was no evidence presented, whether it was the inadmissible evidence of De Jesus or the evidence of the testimony of Mr. Pados, that said that this area where he was at the time was normally exposed to falling debris or falling objects.
Is that it? Thank you.
I'll rest on my brief. Yeah.
Okay.
Mr.
Isaac, you have 1 minute.
Yes, I'm going to be brief, Your Honors. My adversary said that there was no testimony that plaintiff knew that Mr. Jennings was working above him. That is not correct. I'm just going to give you the pages, starting at 242, line 17 to 244, line 3. Not only did he know Mr. Jennings was working above him, but he also testified unequivocally that there was a pre-work meeting in which all of the workers were told that they would have to realign the 30-inch vertical rebars, which were misaligned. My adversary also said there is no evidence that the plaintiff knew what struck him. That is also just not correct. 246, line 5 to 246, line 22, he gives a complete description. I believe, Judge Renwick, you were referring to it. And we would ask you not to search the record and grant summary judgment, dismissing the claim on which we had summary judgment, where the defendant didn't appeal. The decision was correct on the law, and in the absence of an appeal, it's not something you should do, although you can do it under the Merritt Hill Vineyards case. There's nothing further. Thanks for listening to me.
Thank you both. Wimbledon Financing versus Catton Mutual.
Your Honor, before Ms. Rice speaks, can I just confirm that you can hear me?
Yes, I can hear you.
Perfect. Thank you very much. I've been having technical problems.
I know. I saw you earlier.
And I apologize.
It's okay.
Okay,
Ms.
so
Rice?
the question turns to me. Can you see me since I cannot really
Now
see?
I can see you. Yes, I can.
Okay, excellent. Thank you so much, Your Honors. May it please the court, Michelle Rice on behalf of Wimbledon, the appellant. Catton's motion to dismiss the Wimbledon complaint is based solely on statute of limitations grounds. Catton did not move to dismiss Wimbledon's complaint for failure to state aiding and abetting claims.
Counsel, I want to just put this in the right context, because in viewing this, we have to look at these allegations in the light most favorable to the plaintiff. Is that right?
Yes.
Would you agree?
Even under,
so,
yes, even under A5, Your Honor. Yes.
Okay. All right. Okay. So let me hear then what you have to say with regard to those pleadings. I just want to make sure we're all on the same page with regard to that.
We are. Thank you. Well, my principal point and where I started, Your Honor, is that Catton has waived its right to raise arguments that by not moving for failure to dismiss. Its brief is littered with arguments about whether or not we've pleaded substantial assistance. Its argument is littered with things about whether or not Catton had actual knowledge of the fraud. Catton did not move below under CPLR 3211A7 for failure to state a claim. And as the Court of Appeals instructs in the McLearn v. Cowan case at 60 New York 2nd at 686, it would be error for this court to consider failure to state a claim arguments given Catton's failure to move on those grounds below. Let me move, though, to the dozen or so disguised malpractice claims that are cited in the briefs, including.
Well, okay, go ahead.
Okay, there are exactly two of those cases which present a posture that is similar to this case. The Neogenics Oncology case and the Eastern District case 2015, and the Kislev Partners versus Sidley case, which is a commercial division case 2019. In both of those cases, the defendant law firm moved to dismiss aiding and abetting claims as time-barred disguised malpractice claims under CPLR 3211A5.
Excuse me, Counsel.
And A7.
Yes. But in this instance, the plaintiff is alleging intentional acts. Malpractice, legal malpractice is a negligence claim, as I'm sure you know. And the plaintiff here is alleging intentional acts. And this is, if I'm correct, a motion to dismiss. Is that right?
That is correct, Your Honor. And I'm going to add to that.
Ms. Berg represents the plaintiff.
Right. So I'm sorry. We get the plaintiff every reasonable, or the asserting party every reasonable inference here.
That is correct. And I'm going to go one step further. Wimbledon, the plaintiff did not sue Catton for fraud. It did not sue direct fraud. It did not sue Catton for breach of fiduciary duty, and it did not sue Catton for negligence. So we submit that the court simply went astray or was led astray.
Counselor, this is Judge Singh. The part of the appeal that gives me concern is the whether or not the aiding and abetting claims are time barred. So can you address that issue with specificity, starting with the breach of fiduciary duty? Is it a 6-year statute of limitations or a 3-year statute of limitations?
Yes, I can. Of course I can. The essence of this case and the essence of the underlying Wimbledon plenary actions is that Albert Halleck, Wimbledon's investment advisor, was engaged in a massive fraud scheme carried out over a period of 4 years. The breaches of fiduciary duty he had to Wimbledon and Partners, to our clients. He has pleaded guilty to 5 counts of investment advisor fraud, securities fraud, and wire fraud. The breach of fiduciary duty claims are not 3-year claims, they're 6-year claims because they're predicated on fraud.
And what's the actual fraud in this case they're predicated on?
Albert Halleck's fraud scheme, of which there are many frauds, Your Honor. But I could go through, I could run through the list. They start in 2009 with taking a bribe from Jason Galanis to merge.
How do you, for example, how do you get that first one that you're talking about, taking that bribe in, that ends, I think, in 2011, with a 6-year statute of limitations? How does that get you to the July 2018?
Because it ends in 2013. I'm sorry, and this is a mistake that the court made as well. Let me give a thumbnail sketch of the frauds, but I will tell you.
Why don't I just ask you another question? Which I have.
They counseled Wimbledon about the Jarova transaction that.
Counsel, I have a question. So this Jarova transaction that you're talking about, that this transfer of stock for the assets, that was in January 2010.
That's correct.
Okay.
That's correct, but it doesn't end there.
I beg your pardon?
It doesn't end. The transaction doesn't end when Jarova falls apart in 2011. So then the assets get diverted away from the rightful owner, Wimbledon, who Catton was consulting with at the time about the transfer.
Are you suggesting, because you say it doesn't end, I think it ended when the stocks were transferred. That was in January 2010. Then they were exposed to another fraud in January 2011. I'm sorry. I think then Forbes, there was an article in Forbes in January 2011. So, by that time, everybody would have known that what happened with the Jarova stock. It was pretty widely known. So it seems like was that not ended?
Everyone doesn't know, and we did not plead that Wimbledon knew, but there appears to be a misunderstanding as to exactly what Wimbledon is. Wimbledon is a Cayman Island investment funds. The only people that ran Wimbledon were either the 3 directors in the Cayman Islands or Albert Halleck, the person who's been convicted on 5 counts of fraud. All of the activity directed in the United States and all of the communications which reveal Jarova as a fraud were in the United States. The Wimbledon directors in the Cayman Islands knew nothing about it.
Let me just ask you a different question.
Okay.
Are you relying on a doctrine, example, maybe continuous wrong doctrine or something else to link these different allegations of fraud?
Yes, we absolutely
okay. Well,
are.
I was trying to find out what it was because you keep talking about the statute of
no, I apologize for talking.
Yeah, go ahead.
Yes, we link absolutely the Wimbledon transaction in the Jarova transaction, which is when Wimbledon contributed their assets to Jarova and got worthless stock in exchange. It then gets unwound in 2011 through a transaction that nobody knew anything about. And that theoretically, Wimbledon should have gotten everything that was still around that hadn't been stolen back, all of its assets back. But instead, as Catton knew, instead those assets go into a different transaction. It's called the Arias Libra transaction. And the little bit of cash that Wimbledon had left, $5 million, goes to all of the Jarova fraudsters, people that are all in prison right now as we speak, including Jason Galanis, who's serving a 16-year sentence because he's a recidivist fraudster. So the Arias Libra transaction doesn't get finalized, and Catton vouches for the Arias Libra
Counsel,
transaction.
This is Judge Gonzalez. So just explain why these aren't separate acts as opposed to continuing acts.
Because they are all directed at Wimbledon and its assets, all and the same assets, for which this case is, as you all know, because you've heard several of them, been going on for a very long time, and we are finally getting judgments. And the judgments for the frauds perpetrated on Wimbledon and Partners 2, frauds that Catton helped facilitate, Catton, Wimbledon's fiduciary, they helped facilitate, didn't end until February 2013, when Catton actually met with the Cayman Islands board to discuss Jarova, Arias Libra.
I think we understand. Thank you. And you have some rebuttal. Mr. Peretz?
Thank you.
Your Honor, may it please the court, first of all, my apologies for my technical difficulties.
We all have technical difficulties. Why don't you go right ahead without further ado?
Very good. Your Honors, in this jurisdiction, we judge complaints by their substance, by their essence, by their nature, not by their label.
But we do look at complaints at this stage most favorable to the plaintiff. These are plaintiffs. This is plaintiff's complaint, and we view the complaint in a manner most favorable to plaintiff. Is that not correct?
That's absolutely correct. And by that standard, appellant loses, Your Honor. Right? If you look at the complaint, all the complaint says in determining whether this is a malpractice case that has a 3-year statute under 214.6 or something else that may have a longer one, you look at the complaint and giving them the most favorable inference, you will see that there is nothing in there other than Catton failed to advise this, failed to tell this person that.
Well, I think it's the this and the that that are, I think it's the this and the that are things we have to look at. They're saying that, for example, they're saying, for example, that Catton was aware that Halleck had been charged with securities fraud and wasn't supposed to be involved, yet they consulted with him and didn't tell the trustees of plaintiff that they had consulted with him, that he was part of this whole deal that was taking place. I mean, is that, and they're saying that since they knew that, that was an intentional act, not just negligence, not just malpractice.
Your Honor, this court's decision, and then there are many of them, talk about a failure to disclose things as a quintessential act of malpractice, period. It doesn't matter what it is. That's why we can say this and that, and we don't have to fill in any blanks. If malpractice is a failure to advise people of something that the plaintiff now, years later, says he would have wanted to know. And here, the question is, what is it that elevates that to something other than a quintessential malpractice claim? This court has several precedents that speak to the duplicative claims doctrine, and that rule intended to make sure that people didn't try to find loopholes out of the import of 214.6, say very clearly the Johnson versus Proskauer case, Your Honor's case of Garari against Green, another case called Abandonolo, and some other ones that we cite, say you need to do two different things, both of them, in order for you to avoid a 3-year statute of limitations. You have to, in the first place, plead a fraud or a participation in a fraud that is independent and extrinsic to the attorney-client relationship. And second, and again, it's and not or, you have to prove or plead damages that are different than what would be pleaded in an actual malpractice case properly titled. If you miss one of those tests, this is a malpractice case, and Wimbledon misses both of those tests. In reverse order, the damages claim is absolutely identical to every legal.
Counsel, if I may. So the plaintiff alleges that Attorney Catton helped Halleck steal money from the plaintiff, right? How does that fall into how does that jive with what you're saying, that this was part of the attorney-client relationship, that stealing money was malpractice?
If you look at Catton didn't steal anything, Your Honor, and that's not alleged. And Catton didn't get anything here other than its hourly rate like any other law firm in any other case does. If all you have to do is to take a standard malpractice allegation, they failed to do something with the effect that a bad thing resulted, that's a malpractice allegation. If all you have to do is to say, but by doing so, you aided and abetted a fraud, or you substantially assisted a fraud, then 214 sub 6 has just vanished into the maw. You look at the allegations, what it is that Catton is charged with having done or failed to do. And in this case, over and over and over and over, it says they failed to tell somebody something. And we can talk about what the somethings are until the cows come home, but that's a malpractice allegation. Right? And that is exactly the kind of allegation that this court has routinely held doesn't get you out of the duplicative claims doctrine. It's malpractice, whether you like what the result of it is or not. Something bad happens in all of these cases. That's the nature of a plaintiff's malpractice claim or a fraud claim. But to get back to the Johnson and Proskauer discussion, right, the damages that are being alleged here are absolutely identical to what any malpractice case you've ever seen will allege. They allege damage to the fund. They allege they should get their attorney's fees back. Those are quintessential malpractice allegations. And we should stop there because that satisfies the rules that this court has set forth in several different decisions about having to plead, even with the benefit of every favorable inference, both of those tests, but they missed the second one too. They don't say that Catton actually affirmatively did something. What they say is Catton failed to disclose things, or they disclosed things to the wrong person. You know, it's ironic that we have that discussion because the complaint also says that Catton counseled against the Jarova transaction in the first place, that Catton advised the board on how they get their assets back on June the 11th. That's page 36 and page 39 of the record. It says Catton counseled against the Arias Libra transaction, in which, by the way, Catton had no involvement whatsoever, and the complaint doesn't say otherwise. It says Catton actually drafted an agreement that was intended to unwind and get Wimbledon back its documents, and it says that Catton sued the fraudsters in Arias Libra and obtained a $7 million judgment. All of those things appear in the face of the complaint itself, and you just can't say those things and at the same time say Catton is part of a fraud. Now, all of those things, I would respectfully submit, means that the plaintiff cannot satisfy either of the tests set forth in the Ferrari and Abandonolo and Johnson and a number of other cases. If you took out all of the allegations that this court repeatedly holds to be classic malpractice allegations, all of the failed to say or failed to advise or advised the wrong person allegations, if you took those out, then what you'd have left is nothing, because there's no affirmative conduct alleged as against Catton, and the idea that it would toss its hat in with fraudsters to defraud its clients is absurd on its face. Right?
Thank you.
If may I say two more things briefly?
Sure. Wrap up and yeah, sure.
Briefly, I'd ask you also to look at section 305B, because the summons with complaint plainly violates its jurisdictional requirements, and as a consequence, the statute of limitations hasn't run. If you took this complaint, last sentence, I promise.
Those are not amendable issues?
Jurisdictional, it's too late.
No, I understand. I'm saying, are they truly jurisdictional issues? Okay.
The Roth against the Dormitory Authority says it's jurisdictional, and if you don't have a summons, you don't have a case, the statute keeps going. That's what's happening here. If you took this complaint and filed it within 3 years and called it a malpractice case and didn't change a word, there isn't a court in the world that would entertain a motion to dismiss it for failure to state a claim. This is a malpractice claim, Your Honor, pure and simple. No matter what you call it, this is not a way out of the 3-year statute of limitations. Thank you very much.
Thank you. Ms. Rice?
Let me address his points. Catton was Wimbledon's fiduciary. In Kaufman versus Cohen, an aider or abettor defendant that is a fiduciary to the plaintiff cannot simply stand by, watch others commit crimes, help them to conceal material information from a fiduciary. So Mr. Portz's statement that it's okay for a lawyer to ignore the facts that it learns about his client, his other client, Halleck, committing crimes is completely inaccurate. To quote Kaufman v. Cohn, the mere inaction of an alleged aider and abettor constitutes substantial assistance if the defendant owes a fiduciary duty directly to the plaintiff, which he cannot deny is the case here. So the notion that we've only pleaded malpractice and it's based only on their failure to disclose things to us, one, is not accurate. We cite a number of things throughout our complaint.
Can you address the damages issue raised by your adversary? Essentially, they're the same damages as for malpractice?
My adversary, and frankly, the court below ignored, yes, I can, and thank you. My adversary in the court below ignored paragraphs, or paragraphs 102 to 111 of the complaint, which is at the record at pages 49 through 50. Those 9 paragraphs of the complaint are entitled Damages Sustained by Wimbledon and Partners 2, and they detail the various defalcations from Wimbledon and damages resulting from Halleck's fraud scheme against Wimbledon and Partners 2. These are not malpractice damages. These are compensatory fraud damages for which we currently now have, as against the investment advisor and the various aider and abettor, a $40 million judgment. These are not malpractice damages. The court just ignored that section of the complaint entirely, focused on the demand for judgment at the end, but there ignored section B, which is talking about compensatory damages. So my adversary is just wrong, frankly, Judge Singh. I want it to be clear, one, I am relying on the continuing wrong doctrine, and the last fraud vis-a-vis Wimbledon, as alleged in the complaint, is in February 2013, meaning the aiding and abetting causes of actions which have 6-year statutes and discovery provisions are timely. And they did not move to dismiss the aiding and abetting causes of action for failure to state a claim. They still exist or should have existed and can't be swapped out for an unpleaded claim of negligence under 3211A5, they would had to have moved to have those the aiding and abetting claims dismissed. They
Thank
didn't
you.
do so.
Ms.
Thank
Rice,
you, Your Honor.
Mr. Peretz, thank you very much. Thank you both. Moving on, Bay versus Rosado.
May it please the court, my name is Yolanda Ayala and I represent defendants appellants Jose Rosado and Ryder Truck Rental in this matter. It's the defendant's contention that the trial court erred in granting the plaintiff's motion for partial summary judgment on liability because it was premature. That is because the plaintiff.
Counsel, let me stop you there for a second. When you say it's premature, are you saying that there needs to be discovery before the motion can be properly heard on renewal, et cetera? Or are you saying that there are issues of fact based on the competing affidavits of the parties here? What's your position?
I'm actually arguing both, Your Honor. My first argument was that the court should have just denied it on prematurity because the defendants were not given the opportunity to cross-examine the plaintiff at a deposition in terms of his account of the accident. But even if you assume that the case was not premature, the affidavits and the police report submitted raises various issues of fact as to how the accident occurred. The police report makes no mention of it happening on the sidewalk, whereas plaintiff claims in the affidavit it did occur on the sidewalk.
That fact alone, however, wouldn't prevent the plaintiff from getting partial summary judgment.
Well, I think that contradiction, as well as the fact that Rosado provided a very detailed affidavit indicating that the accident occurred because plaintiff essentially walked into his truck because he was just distracted by his cell phone, was sufficient to raise a triable issue of fact.
So you're saying that the defendant Rosado is saying that he was not responsible at all.
Correct. So under Saval against New York City Transit Authority, 173 AD 3566, this court specifically held that where defendant provides a version of an accident that exonerates him upon the basis that the plaintiff was solely responsible for the happening of the accident, summary judgment is inappropriate. And I think that's exactly
you have 1 minute rebuttal. Thank you. Mr. Versosa?
Versosa, yes.
Versosa, yes.
Yeah, so to go to the point, this as far as discovery not being completed, this motion was not premature.
Well, was discovery completed? Was there any discovery here? Was there any depositions?
No depositions have been held.
So then how is it not premature?
Well, while it is normal to take discovery into account, when both sides have essentially presented each side on its papers, then at that point it would be.
So then let me stop you there, counsel. If that's correct, aren't there two dramatically different versions of the accident? The truck driver essentially says that your client was distracted and ran into the passenger side of the truck, and the plaintiff's position is that he had already crossed, and as the truck was turning right onto Pearl, he was hit by the back of the truck. Who's right on that case?
Well, so what the trial court had decided, which I do happen to agree with, is the fact that the accident did happen in the crosswalk. That is what. But
I think you're missing that. I think that the plaintiff says he was that the truck went onto the sidewalk. You said crosswalk, but went onto the sidewalk. And what the driver said is, not only did I was never on the sidewalk, but he said, I saw this person walking straight down the street, going in the same direction I was. And when I went to turn, he was nowhere in front of me, next to me. He was not there. Only when I was turning and I turned, I heard something and he came up to the car and said, I hit him. So what he's saying is he was not within his view at all. He was not in front of the car. He was not in his line of where the car was going. It was the back of the car that this person walked into because he was on his phone. That's what he's saying, which is different than what you just said, he said, which is what Judge Singh is saying is totally and diametrically opposed to what your client is saying. So doesn't that then raise an issue of fact that prevents your client from getting partial summary judgment?
No, it does not. The operative fact here is that my client's version is that he was struck on the sidewalk. So there's my client's version. The version
okay, but that's not the only version.
Exactly. So the version of the fact that my client was involved in an accident while in the crosswalk, per the VTL, that that should determine liability.
So if a truck is halfway or 3/4 of the way through a crosswalk, the driver at the steering wheel no longer within my view, and I am talking on my phone and walk into the rear of the truck, the truck is responsible?
Yes, that doesn't eliminate any arguments as to comparative liability. So we can certainly have.
How is the truck responsible if the person walks into the crosswalk when the truck is there, already proceeding significantly through it? How is that, knowing that there's no way that the driver can see them?
Well, it's, the truck, while making a turn, must yield to pedestrians who are approaching a crosswalk, about to cross the street.
That's not what this driver says, but anyway. Do you have anything to conclude?
I don't. Yeah. The defendant, they do say that they did see this plaintiff before they were crossing the street.
No, not before they were crossing the street. Before, when they were walking straight down the street in the same direction. That's why he's saying that he was nowhere in front of my car, because I saw him, I passed him. Anyway, thank you very much. On to Ms. Ayala again.
Your Honor, I think I'll quit while I'm ahead. Thank you.
Well, I'm not guaranteed, I'm not saying you're ahead. We just ask questions. If you have nothing further to argue, that's okay.
I think your Honors have noted this is a battle of affidavits, and that's inappropriate on a motion for summary judgment.
Okay, thank you very much. Thank you both.
Thank you.
Aspen Specialty, thank you both. Aspen Specialty versus RLI Insurance.
Good afternoon, Your Honors. Joseph D'Ambrosio on behalf of the appellant, RLI. Your Honors, there are two issues on this appeal. One is my client bound to a decision in an earlier action to which it was not a party. And second involves a priority of coverage issue. Let me start with the first issue, which is we believe outcome determinative. The trial court ruled that the law of the case applied such that my client is bound as a matter of law and does not get to argue the merits as to the interpretation.
So why doesn't law of the case doctrine apply here, sir?
The law of the case doesn't apply, Your Honor, because it doesn't apply to different cases. This is a different case, and my client was not a party to the prior action. So on its face, we submit that it does not apply.
Well, this is a follow form case, isn't it? Isn't it a follow? Oh, I'm sorry, Justice Mazzarelli. This is a follow form case. Why wouldn't it apply in this instance?
Your Honor, absolutely. This is a follow form excess policy, but follow the form excess policy does not mean that we are bound by the outcomes. We followed the form of our insurer's policy. There's no question about that. We do not dispute that. But there's a big difference between being bound as a matter of law versus in the normal situation, we're going to lose because normally courts do not interpret policies in different ways. But this is not a normal situation. The Aspen is trying to submit to you that this is just a normal situation of an excess follow form insurer. We submit to you that, but for the change in the law, I would still have my opportunity to argue in court. Most likely, judges would, show me the door quickly because it's already been interpreted. But this is not a normal situation. This is a unique situation. There was a change in the law regarding interpretation of that very same policy language. So therefore, I do get an opportunity to be heard on the merits, which the trial court said I was not entitled to. Now, I respectfully submit that Aspen concedes, to me, they concede that law of the case does not apply, because in the very first argument they make in their brief, Your Honors, they say this court, which is true, has the authority to affirm on any other ground that it sees fit. And now they go to that excess argument, and we submit that we don't even dispute that we have the same language. We just say that means that we follow the form, but that doesn't mean we're bound by the outcome, even though in practice, most of the time, almost all of the time, we probably will end up with the same result. This is a unique case in which we're entitled to argue the merits, and because of the sea change in the law in light of the Burlington decision, the outcome is different. So that's on that first point, Your Honors. We submit that if the court, allows us to have our day in court and addresses the merits of this issue, that RLI does not owe coverage for this incident. The second part of this is the second issue, Your Honors, is priority of coverage. And we submit that the court also erred in that if the court reaches that. And the reason is...
And that's my question to you, Counselor. Do we need to reach that issue?
No, Your Honor, absolutely not. If you find that we are entitled to our day in court because this is a unique situation in which we are not, and we are not bound because we have, just because we happen to follow the form, that doesn't mean we're bound as a matter of law, then I submit, Your Honor, that that will dispose of the case, that we do not have to reach the second issue. I only address the second issue in the event that the court does not rule on that issue. So, and I just will quickly go through that issue. Again, we believe it was erroneously decided. The premise of it is that both policies are excess, which flatly is wrong. It's just wrong on its face. Aspen is a true primary policy. It's in the record. There's no underlying insurance. RLI's is a true excess policy. Our insurers is underlying insurance. That was the premise. That's a false premise. And then the main argument is we have an endorsement that says, to the extent required under a written contract. There's no reference to that language in the decision. The court didn't address the language. To us, that is the key triggering language. It says, to the extent required under a written contract. The written contract is the trade contract between the hotel and the elevator company. So we take a look at that, and that contract's in the record. And
why isn't Aspen correct that we would look at the language of the policies to determine priority?
Oh, absolutely, Judge. You always start with looking at the policy language, and they're asking you, to look at the policy language in the RLI policy, and then we have an amended endorsement, and we acknowledge that. And if you look at that language, Judge, it says, to the extent required under a written contract, my RLI policy would apply before other policies. Okay, they're reading that language, to the extent required under a written contract, completely out. They're just ignoring it right as if it wasn't there. But when you apply that as written, that's the policy language. The policy says, let's look at the trade contract. We then look at the trade contract. This particular one doesn't have any language about priority. It just says, you should get us additional insured coverage. Nothing whatsoever about priority. They want you to just assume that it should be all the AI coverage is first. It doesn't say that. And the courts don't read terms, especially the terms like this, into it. These are terms of art. In these construction contracts, you see primary and not contributory all the time. This contract doesn't have it. If this was a different contract, then maybe it would apply. It doesn't apply here. So then if the excess amendment doesn't apply, we go to the regular other insurance provisions. And the regular other insurance provisions governed by Bovis Lend-Lease and even a Sport Rock case that the trial court cited specifically say this: when you have a true excess and a true primary, it says that, this is a quote from the Sport Rock case from this court, an excess other insurance clause will not render a policy sold as primary insurance excess to a true excess or umbrella policy sold to provide a higher tier of coverage. So those are the reasons why, if you reach the second issue, Your Honor, we respectfully submit that our policy is excess to the Aspen policy. And if there are no other questions, I'll leave it to my adversary.
Mr. D'Ambrosio.
Thank you,
Mr.
Your Honor.
Rader? Sure.
Thank you, Your Honors. May it please the court. Your Honors, there's two insurance policies, and we need to figure out which one comes next in line.
So, counsel, I want to ask you, was RLI a party to any of the Iron Shore declaratory judgment actions?
They were not a party, but they knew about them. They had to contractually know about them.
Well,
as a
then
matter.
that they don't have to jump into the thing. That would have been for somebody to implead them, right? No one
Right.
brought them into the action.
That's correct, Your
Iron
Honor.
Shore
It was.
didn't bring them into the action.
That's
Did they?
correct, Your Honor.
Okay, so then they're not bound by anything that happened in the actions with regard to Iron Shore, are they?
Well, the reason they're bound, Your Honor, is because their policy states that they shall follow the underlying policy in all respects. And that language was
Well,
missing.
that is true. That language, that follow form language I was talking about before is significant. But how do you attach that where the party did not have an opportunity to be heard in the particular action?
Well, I would submit,
There's
Your
no
Honor.
collateral estoppel, no res judicata effect here. They weren't in it. They weren't brought into it.
That's right, Your Honor. But they had the opportunity to participate if they wanted to participate. And by not participating, that's fine. They didn't need to. But now they need to follow the underlying insurance in all respects. And again, their policy right before that, it says the policy is subject to all of the conditions, agreements, exclusions, and limitations of the underlying insurance. And
what about the fact that this case here was it's contrary to the law at this point, given the Burlington case, and
so
this was Transcell's policy, right? RLI is Transcell's policy, and Transcell was not a proximate cause of the plaintiff's injury, and so according to Burlington, RLI wouldn't be an excess for Alphonse.
I think that's right, Your Honor. And according to that reasoning, which is true, the underlying insurer also wouldn't be responsible. And they made that argument. They said to Justice Engoron, you need to change the ruling against us because the law has changed. And Justice Engoron said it's too late. There's a rule in New York about finality of judgments, and they cannot now benefit from that ruling. And
that sounds like Iron Shore's problem, not RLI's problem.
Except for the fact that the RLI policy expressly states that it shall follow the Iron Shore ruling in all respects. And the reason it does is because follow form policies is a matter of policy and contractual language, especially here. They need to follow the underlying policy. This department made that clear in the Midland case, where it said that normally the follow form policy would follow the underlying policy. There, it actually, the excess policy did not follow the underlying policy.
But Counselor, I guess I don't understand your argument, because if RLI is not bound by the prior order, either through res judicata, collateral estoppel, or law of the case, why can't it put forth the correct interpretation of Burlington now?
Because they're bound by the adjudication that applies to the underlying policy. That's just their policy.
But then you're saying they're bound by either law of the case doctrine, collateral estoppel, or res judicata. It's going to be one of the three.
Law of the case. It's the law. That's what Justice Engoron found.
But how? If they're not a party to that litigation, where they've not had an opportunity to make any arguments, how can they be bound by even law of the case doctrine?
Well, they had the opportunity to participate if they want. That's just the excess carrier.
Conversely, you had the opportunity to bring him into the prior litigation.
That's true, but the way the policy is structured, it's their contract, and the way their policy is structured is that they're bound by what happens to their underlying insurer. They don't dispute that if there was a sea change in the law in the opposite direction, they would get the benefit of it. That's just the way these follow form policies work, that they follow the interpretation of the underlying policy. And so that's why when Justice Engoron said that it's law of the case, what he said is that it's law of the case that the Iron Shore ruling can't be changed. And once the underlying ruling can't be changed, that is outcome determinative for RLI. That's the contractual bargain.
Even if the law changes.
Exactly. Now, if the law changed.
So how do you explain, for example, the Midland decision?
What the appellate court found, this department actually found, was that the excess policy did not follow the underlying policy in all respects. It actually found that the excess policy was governed by New York law and the underlying policy was governed by New Jersey law. So when
isn't this saying that the underlying policy was pre-Burlington and the RLI policy is post-Burlington?
You're right, Your Honor. That's what they're saying. But the distinction is that in this case, this RLI policy follows the underlying policy in all respects. In that case, in the Midland case, it actually didn't follow it in all respects, meaning even at the time the original policy was interpreted, there would have been a different outcome reached because the underlying policy was governed by New Jersey law and the excess policy was governed by New York law at the very same time. There never would have been a distinction at the time the two policies were being interpreted as to which
the
policy.
language in those two policies, let me understand, the language in those two policies were the same. They were follow form.
They were follow form, but I don't believe, although I haven't looked.
The law was different.
The choice of law was different at the time, so therefore they didn't follow the policies in all respects. I'm not just hanging this argument generally on follow form policies following prime underlying policies, although that's an important component. Here, the language actually goes further, and it's an unusual policy for those who do excess insurance. It says that it shall follow the underlying policy in all respects. That's after saying that it's bound by the same terms, conditions, etc. So when my adversary says that it just means that the conditions are the same, it would render the phrase in all respects superfluous, which is why in his brief, he didn't even in his moving brief give any alternative interpretation to the phrase in all respects, because there is none other than that if the law applies to one, that same interpretation as a matter of law applies to the other. So I'll briefly touch upon the other argument, the argument of the other insurance policies. He claims that in his reply brief that Justice Engoron didn't do the analysis. He did. The maintenance policy that my adversary is referring to specifically required that this hotel be named as an additional insured on the relevant policies, on the RLI and on the other policy too, on the underlying policy. So this was required by the underlying insurance. And it's not true that my policy is just like the true primary. My policy says, the Aspen policy says, it's excess over any other primary. That's what it says. So on its face, it specifically says it's excess over a primary. And then there really can't be any dispute. The other policy, the RLI policy, says that when it's required, and here it was required by the maintenance agreement, it says that it becomes the primary policy after its underlying policy, the Ironsure policy, is exhausted. And that's why Justice Engoron already found that the Ironsure is primary, and then we come next.
Okay, thank you. Thank you. Mr.
Yes, Your Honor. Yeah, I just want to touch upon a few points. First, there's a lot of discussion about, Ironsure, and they had their, everything boils down to every other party had their day in court, Your Honor. Ironsure.
What about what counsel said, that RLI could have moved to join that case?
I'm not aware of any obligation that they would have had to join the case. And let me give you the context of, why there was no reason, even if they knew about it, Judge, why there would be no reason to. Because here you're dealing with an underlying action in which we don't even know what the exposure is going to be. And you have two primary carriers litigating these issues. There's no indication, there's nothing to suggest that it's going to reach an excess layer. You have $1 million primary policy with Ironsure. You have $1 million primary policy with Aspen. There's no suggestion. We have to jump in to determine priority of coverage issues and any other issues that would relate to us when those issues may not even be reached or may be moot.
What about counsel's other point about bound by the terms in all respects?
Yeah,
being something that,
this is a follow the form, Judge. And the last sentence of that paragraph talks about it. This includes changes by endorsement. It's referring to forms. It's referring to, and we've never disputed that, Judge. So let me give you an example. If they have a policy that provides additional insured coverage, and we don't want to provide any additional insured coverage, for us not to be bound by that, we'd have something that says, notwithstanding anything to the foregoing in the primary policy, we do not provide additional insured coverage. Then we wouldn't be bound. But let's say, for example, on the other hand, that their policy, the Ironsure policy, had an AI endorsement, and say it was the arising out of the broader language, and then we had our own separate one that didn't say it overrides it. It just had the cause by language, the Burlington language, so that there's some dispute, conflict between the two, or then we would be bound by the primary because we didn't say that we're not going to be using that one. So, but it's really dealing with the forms, and here there is no dispute that we followed their form. But it all comes down to, am I entitled to my day in court? Why are they trying to cut me off at the pass? Why are they not allowing me to deal with the merits, Judge? Because they know that the law has changed, which changes everything. Because without that change in the law, I would come to court and I would say, maybe I would come up with a new argument about why the law should be different, and the court would probably throw me out. That's not this case. This is a unique case, and I'm entitled to my day in court. Thank you, Your Honors.
Thank you. Thank you both.
Thank you, Your Honors.
Cruz, thank you. Cruz versus Sharkey's Trucking.
May it please the court, John Shaw for the plaintiff appellant. Respectfully, Your Honors, the lower court erred when it declined to grant our motion for leave, putting aside in our initial BP, albeit it was boilerplate language. There was an allegation of anxiety, depression, and personality issues. There was an impact there. But first of all, there's
Counsel, this case was delayed. I think the motion was delayed for 6 years. It wasn't brought until 6 years after the original bill of particulars, and then it was 4.5 years after filing the note of issue, and after serving 2 supplemental bills of particulars, I think. So there were no MRIs, no scans in this. It's now, I don't know, nearly 10 years later, and what is there to substantiate the claims here? I mean, usually one says that amendments are freely given, but there has to be some limit.
Totally understandable, Your Honor. First of all, this was not done at the eve of trial, like some of the cases that the lower court and my address.
I understand, but doesn't it prejudice the other party when it's so long and there's no, it wasn't something that was done, contemporaneously. It's not that he said, I hit my head and I have all of this pain and everything else when the accident first happened. Let's say it came up 6 months later, but it didn't. And there's nothing, no MRIs, no CAT scans, nothing to, independent review, any objective evidence here to substantiate.
A few things on that. First of all, the prejudice issue would certainly go to whether or not something was sprung on someone the last minute they had no notice. This is, first of all, with respect, I'll deal with 2 things separately. First of all, with respect to the BP, that was really form over substance. Dr. Kuhn examined my client in 2000.
If I may, this is Judge Gonzalez, if I may.
Yes,
Going along what my colleague just said, you're talking about traumatic brain injury and no notice to your adversary that there was a TBI, no notice that there was severe cognitive impairment. There was no IME possibility afforded to the defendant to evaluate this plaintiff from the beginning to see if in fact there was a causal connection and the extent of the injury to the extent of which it had resolved and so on and so forth. The prejudice here appears to be enormous, just enormous. And there is no filing that mentions a head or brain injury.
2 things on that, Your Honor. There were a few things besides the TBI. There was motor sensory impairment. There was anxiety. There was depression, cognitive issues as a result of the accident, and the TBI was another allegation. But we provided the records of Dr. Kuhn, a board-certified neuropsychiatrist, to the defendant in 2012 and prior to the deposition.
But Counselor, if you're not making a claim with respect to TBI, why would, even though they had the records of the doctor, why would they have an IME? I mean, what would be the point of it if you don't make that claim?
Well, again, Your Honor, that was one of the claims or findings of Dr. Kuhn. They clearly were on notice. They deposed my client.
But if you're not asserting the claim, sir, why would they conduct an IME for a claim that you're not asserting? That would just, it seems preposterous.
Well, with all due respect, on multiple occasions in litigation, There's another claim that arises during litigation where they're not even on notice of a particular orthopedic claim or a neurological claim, and they have an opportunity to conduct a further limited deposition, a further limited physical. There's no question they have an opportunity. This case, and at the time, the note of issue was even stricken. They had and still have ample opportunity to conduct a further limited deposition with respect to claims, with respect to Dr. Kuhn's findings, who was identified and who was questioned by defendants at the
But counsel, let's go a little further here.
Surely.
There's no mention of a TBI at the ER. There's no mention in the letter to the Social Security Administration or to workers' comp. There's no indication at the scene of the accident that the plaintiff sustained a traumatic brain injury, and yet you're saying that the defendant was on notice that there was a traumatic brain injury. How?
They were not on notice, Your Honor, from the Bill of Particulars. Again, they cannot claim prejudice. My client has not gone anywhere or anything. They were given.
But the prejudice, sir, seems to me that 6 years have passed. So how are they to evaluate that claim now, 6 years later, as opposed to, I think the point's been made over and over again, contemporaneous to the time your client started treating with Dr. Kuhn?
Because, again, besides the TBI, they were on notice of the other findings of Dr. Kuhn, whose records they had. And again, in our BP, we certainly asserted psychological components, which are part of the amended BP. Granted, TBI was not that one, but TBI was in Dr. Kuhn's records in 2012, which they had already. And again,
thank you.
Go ahead.
Why don't you finish up, add anything else on rebuttal?
Thank you, Your Honor.
You have a minute, okay?
Sure.
Mr. Reed?
Good afternoon, Your Honors. May it please the court.
So I'm just going to say that, pleadings are to be freely amended,
Yes.
and these are, why shouldn't this one be? That's your position, is that it shouldn't be.
It should not, and primarily that is due to the irreparable prejudice that this amendment would work on the defendants that couldn't be fixed. Just to elaborate on what Your Honors have already touched on, there is absolutely no way if the plaintiff were allowed to make this claim at this point, that we could contest his claim that there had been a TBI over the course of the past 10 years. And he could disregard a finding by our doctor at this late date as to his current condition. And the prejudice right there is on its face. And that's exactly why, in the rare case, amendments to pleadings and claims aren't always allowed. There is a limit.
So I think your adversary would respond is that you've had Dr. Kuhn's record since 2012, so you're on notice of what Dr. Kuhn's findings are, aside from even TBI. So under those circumstances, how are you prejudiced?
We're still prejudiced, Your Honor, in that, first of all, I would refute the notion that the defendants are under an obligation to discern possible claims made by the plaintiff that the plaintiff is not making himself. We're supposed to scour records that the plaintiff is not referring to in his claims. I don't believe that's the law. As a matter of fact, I believe what the plaintiff is saying, that would be incumbent upon us, flies in the face of this court's ruling in the REULING case versus Con Ed, where the court found there that a 3-year period where the plaintiff knew of these records and didn't make the claim precluded him from amending. The plaintiff here is trying to turn that decision on its face and turn that burden on the defendant. It's just not there. Aside from that, everything else, there was nothing else to support this record from Dr. Kuhn. As a matter of fact, it's my understanding that Dr. Kuhn's records were part of the workers' compensation claim. This is not as though Dr. Kuhn's records were exchanged with the defendants as part of their claim for damages. And in fact, Dr. Kuhn's records in the workers' compensation claim, his application for payment were denied based on a finding that they were unrelated to the condition claimed in this case. So every other indicator, despite having, even if we were to concede being in possession of such records, every other indicator from the plaintiff's complaint to his 3 bill of particulars, to all the rest of the medical records, to the plaintiff's examination before trial, transcript, and testimony, refutes any kind of head injury, and the notion that there was any kind of head injury. There was nothing else to corroborate an assumption that there could be a claim here, other than that independent record from Dr. Kuhn.
Thank you. Mr. Shaw.
That's an incorrect statement. Dr. Kuhn was exchanged as part of this case, not about the workers' comp. Workers' comp often finds
Either way, all of the other factors remain, don't they?
Actually, not. They cite to the ruling case, which actually Your Honor was on the panel. And in addition to the Lopez case, the court specifically said it was at the eve of trial or during the trial.
No, I'm not talking about eve of trial. I'm not talking, this is not eve of trial, and that's not what I'm talking about. I understand that. I'm saying regardless of whether it was part of the workers' comp or not, it was there, but there was no reason to have an independent, exam or look into it further when you hadn't raised it even. Is there? Was there?
There is, because they've been on notice and there's no prejudice. In fact, the lower court said basically there was no prejudice. They never even appealed on that issue. And this case is not on the trial calendar. In fact, it's on the pre-trial calendar. It's not even on the trial calendar. They have every opportunity to choose
Let me chime in here.
An expert to challenge Dr. Kuhn.
Justice Mazzarelli has a question.
I'm sorry, Your Honor.
Let me just chime in here and ask you, why did you wait so long?
Agreed. It was really
if it was so obvious and you knew about it, why did you wait so long?
It was understood, Your Honor, form over substance. All the records were given to defendant. In fact,
No, I didn't ask about that, form over substance. Why did you wait so long to do this?
We should have done the technicality and filed a supplemental BP for all the records.
You know, you still haven't answered the question. You still haven't answered Judge Mazzarelli's question.
And I did really listen to everything you all had to say, and nobody seemed to respond to that question. Why did you wait so long? Simple question.
Be very candid. No one filed the supplemental BP to formalize what was already given during the whole course of discovery and during the fact that they even deposed plaintiff about Dr. Kuhn and asked questions. Plaintiff even testified he was on an antidepressant when he was being deposed that day. So they had all the information. The only thing we did not do, and we should have done, was do the formality of a sub BP. They clearly are not surprised, and they're not prejudiced. It's not even on the trial calendar to have a limited EBT and ask the same questions they've already asked, and choose to have a neurologist or a neuropsychiatrist. They did not oppose our motion with any expert affidavit or anything. They have not shown anything about being prejudiced, which is really the law of the case, by the fact that we did not do the amendment timely, but they haven't even shown how they're prejudiced. They haven't had an expert or anything to show how they were prejudiced by the TBI claim, which is also separate from the anxiety claim and other claims in the amended BP. They haven't shown anything by any expert other than attorney verbiage to how they will be prejudiced now on a case that's not on the trial calendar. They have failed to do that on both accounts.
Thank you, counsel.
Thank you, Your Honor.
Thank you both.
Thank you.
Thank you, Your Honor.
U.S. Bank versus Kim.
There we go. Good afternoon, Your Honors. May it please the court. This appeal deals with a very simple issue: whether the trial court erred when it disregarded the plain, explicit, and unambiguous language in CPLR 205A that requires that the judge who dismissed a prior action place on the record specific conduct that demonstrates a general pattern of delay by the plaintiff in order to bar the application of CPLR 205A to allow the plaintiff to restart an action within 6 months. That did not happen here. To put it another way, can a plaintiff restart an action that was dismissed for failure to file a motion for default judgment within 1 year under CPLR 3215C when that order of dismissal did not list any specific findings whatsoever of any specific conduct of general pattern of delay?
So you're saying that 205A, the savings clause, only is prevented if by the failure to prosecute, if these particular requirements are met?
That is absolutely correct, Your Honor. It's black letter law, statutory. When the trial court disregarded, she was disregarding the will of the legislature. It states a plaintiff may restart an action if an action is dismissed for neglect to prosecute, unless the order of dismissal sets forth specific conduct showing a general pattern of delay. And there's no question that that's not part of the order. Although this has not been decided in this department yet, it is, in that respect, it's a matter of first impression. Every other judicial department, appellate department that has considered this issue has ruled consistently that a dismissal for 3215C may be restarted under CPLR 205A unless, and only unless, that order of dismissal lists some specific conduct showing a general pattern of delay.
Okay, so why don't we hear from Mr. Vellante then?
Very good.
Do you have something else? I don't want to.
No, Your Honor. It's the statutory language is explicit. The case law is all on agreement, and the legislative intent says the same thing. So
okay, you have 2 minutes rebuttal.
Thank you,
Mr. Vellante.
Good afternoon, Your Honors. May it please the court, Christopher Vellante for respondent, Robert L. Gordon's LLC. We would submit that the trial court got this exactly right, because Atani and cases like it misinterpret what is required under 205A, and quite frankly, in this case, and the way it is interpreted is basically makes CPLR 3215 ineffective, worthless, for lack of a better term. If you look at, for example, the legislative intent, the legislative history behind, or what the legislator intended when they passed this amendment to 205A, it's clear that what is intended was to clear up those instances where it's unclear whether the conduct, whether the dismissal, I should say not the conduct, the dismissal was based for neglect to prosecute or not.
Yeah, but why is this a neglect to prosecute? They went ahead and they got their default, and right. Then they didn't get the judgment, but they got it within, I think it was 1 month of the year, isn't it? I mean, it was within 1 month. It's not like it was 2 years, isn't it?
I want to make sure I'm understanding you correctly. So
they had the order of default.
Sorry.
No, okay. They had the order of default, right? They got a default, but they didn't seek a default judgment within 1 year.
Sorry, I'm sorry, Your Honor. I thought you were finished. They commenced the action in 2010. The prior action, they did not file an RJI until 2013. Did not move for an order of reference till 2014. And then when they got the order of reference, waited an additional 1 year, approximately 1 year, to file for a judgment of foreclosure and sale. while that was pending, the property was sold in a condo foreclosure action to my client. They came in. There was actually 2 motions made for 3215C, mostly because when the first one was pending.
But counsel, this is Judge Singh.
Yes.
The prior foreclosure was terminated for a fatal flaw, as you're pointing out, but it's not on the merits. So if it's not on the merits, why shouldn't they be given an opportunity to use the savings provision of the CPLR?
Well, the savings provision is clear that neglect to prosecute, as well as other, certain statutory exceptions, do not qualify for 205A. And quite frankly, the section of the statute that deals with the judge's requirement to lay out certain facts comes secondary. It says if it's a neglect to prosecute, then the judge has to lay out certain facts. But whether or not a judge chooses what words they choose in their order, whether they choose to be more detailed or less detailed, doesn't change the effect of the order. It doesn't change the reality.
Most recent case cited to us, recently decided by the 4th Department, seems to make that a requirement that explicit findings have to be made, right?
And I actually I'm glad you brought up that case, because one thing that distinguishes this case from both that case and Atani and cases like it, that during oral argument in the 4th Department, they deemed to take a lot of issue with, is the fact that that was a sua sponte 3215C dismissal. Ours was not. When you do not have sua sponte.
But that statute permits a sua sponte dismissal, correct?
Yes, of course.
It's not as if the judge is doing anything incorrectly there.
No, and I didn't mean to imply that they were. But the difference is that when it's on notice, you have a chance, as required by the statute, to demonstrate good cause, sufficient cause why the action shouldn't be dismissed. And that's what happened in this case. And there was a failure to do that. And that brings you also to what we cited in our brief is the Matter of Westchester case from the Court of Appeals, where they look at a similar statutory provision that allows for a good cause escape hatch, they call it. And they say, well, listen, when you have the chance to save your case via good cause and you fail, you don't get to then to take advantage of 205A. That's exactly the same situation here. And they're explicit on the fact that if they were to hold 205 applicable in a situation such as that, where there's an opportunity for good cause to show why you shouldn't be dismissed, that would make that good cause requirement meaningless. And that's exactly what happens with these types of dismissals, and in particularly a situation like this, where you're given that opportunity. And in fact, they were given 2 opportunities in the trial court level, because there were 2 3215C's motions, and they had a chance, if they felt that there was good cause and Judge McMahon was wrong, to appeal that. They did take an appeal and let it be abandoned under the strategic decision to start this case, which under the Malay case of the Court of Appeals, at least in a footnote, they left open the possibility that abandonment of an appeal and allowing it be dismissed for failure to perfect itself could potentially constitute both a neglect to prosecute for 205A purposes and a voluntary discontinuance, potentially. Obviously, they didn't reach that question, but the Court of Appeals in those 2 cases and others decided, not only by the Court of Appeals but by this department, make clear that the fact recitations do not change the reality of the situation. You have many other statutory provisions where there's a requirement on the judiciary to lay out facts. And when they fail to do so, it's disregarded unless there's a prejudice. And there's clearly no prejudice here to the plaintiff and Judge McMahon failing to remind them of what their own dilatory conduct is. And on top of that, 205A.
Don't we have an obligation, Counselor, don't we have an obligation to follow the statute and to make the findings that, what your adversary says, was the intent of the legislature? I mean, can we just ignore the law?
Well, but the intent of the legislature is clear that it wasn't meant to deal with situations like this. It was meant to deal with those situations that, for example, a one-off dismissal because you failed to show up at a conference, for example. It's meant to clarify those issues where it's not clear whether it's a neglect to prosecute or not. 3215C dismissals have never been a question as to whether it's a failure or a neglect to prosecute. It's always been deemed that way. It's always been looked at that way, and the amendment doesn't change that. And quite frankly, I said the problem with the Tani in cases like it is they treat the fact recitation requirement as a condition precedent to it being a proper neglect to prosecute dismissal, when really it's the other way. It's when there's a neglect to prosecute dismissal, or then you have to lay out these facts. And to hold that it doesn't, or it's required, affects a litigant by the whims of the judiciary and subjective standards. Just today, a decision came out from the Second Department where, for example, the justices, there was a dissent by Judge Barros in the Second Department where the judges were essentially arguing over whether a specific order, what facts were in it, whether that constituted a sufficient laying out of details of whether there's a general pattern of neglect. So you have different judges looking at the exact same order, coming to different conclusions, which is against what court case law has always told us, which is you need definitive standards when it comes to the statute of limitations. And the way in Tani and cases like it have been interpreting is the exact opposite of that. It creates nothing but fact-sensitive, subjective analysis of situations, which is not how the statute of limitations is supposed to be determined. And I would submit that
if you just wrap up.
Sorry, I'm sorry. Thank you, Your Honor.
Okay, I was going to let you finish your sentence, but all right, thank you.
Unfortunately, I lost my train of thought, but thank you, Your Honor.
It's okay. I think you made a good argument. Mr. Pollack.
Thank you, Your Honor. I would just like to briefly respond to those points. My first point is that this is not a case where there's a factual dispute of what's in the first order. There is no dispute. The first order says, I'm going to read the entire order. It's going to take me about 10 seconds. Movant's motion is granted. Order that the September 9, 2016 order is hereby vacated. Order that movants are permitted to appear in this action pursuant to CPLR 1018. And here's the most important part of this. Order that movant's motion to dismiss this action for failure to seek a default judgment within 1 year defendant's default is granted. And the clerk is directed to enter judgment dismissing this action. That's it. There is no question whatsoever that anybody can read that language and have a debate of whether there's any specific findings of conduct showing a general pattern of delay or not. Obviously, there's not. There's no specific findings of any conduct, period. So that argument is unavailing to the facts of this case. Now, respondents' counsel seems to be making the argument that the statute CPLR 205A should read that anytime there's any dismissal for 3215C, that means that's automatically neglect to prosecute, automatically the case cannot be restarted. But that is not what the statute says. The statute lists specifically which types of dismissals are automatically a type of dismissal.
3215C is not an enumerated exception to the statute.
It's not. And the point, and that's exactly correct, Justice Singh. But it does list other specific types of dismissals which are enumerated and which are necessary. The legislature's decision not to include 3215C should be interpreted by this court as an intentional omission. It should not be read into the statute when it's not there.
Thank you.
I just had a couple more points if I do have a few more seconds. I know my first argument was short.
Go ahead.
Thank you. Responding counsel's argument that this only applies to dismissals that are sua sponte versus dismissals on the merits. That's not correct. The Second Department decided the Janvier case, HSBC Bank USA NA versus Janvier, JNVIER. That's 187-83D 999, Second Department 2020 case. That case was a motion to dismiss. It wasn't a sua sponte dismissal. It was on a motion. And the Second Department said the same thing. The prior order didn't have that specific findings setting forth conduct, general pattern, delay. Therefore, 205A may be used to restart. In fact, every single case that we've cited and that apply this 2008 amendment, the current version of 205A, all the courts require this specific finding made. It's not just one or two courts require it. Every single one requires it. It's a part of the statute. Courts don't have the authority to pick and choose what they want to comply with on a statute. They must comply with the statute as it's written.
Council, it's also a specific amendment to the statute in 2008, isn't it?
That is absolutely correct, Justice. 2008, the statute was amended specifically to include this new sentence that requires that specific finding of conduct demonstrating a general pattern of delay. So based on that amendment itself, I think we can infer that the legislator intended that to be a part of the statute and to be complied with by the court. The last point I want to make is responding counsel's reference to the Westchester case. That case is completely inapplicable to this one here. CPLR 205A was not found to apply because in that case, the case revolved around a completely different statute. It wasn't the CPLR, it was the RPTL. And the court held that the RPTL had its own rules and statutes about restarting actions that are dismissed. So the court said, well, we'll comply with what the RPTL says. We're not going to, the CPLR doesn't even come into play here. And since the RPTL didn't have that specific requirement that CPLR 205A has, the court did not want to read that into the RPTL.
Thank you. Now I'm going to stop.
Thank you. Have a good afternoon.
Thank you both. Very good arguments. Thank you. Verma versus the Department of Education.
Good afternoon, Your Honor. May it please the court, Daniel Dugan for the appellant, Mr. Verma. The appellant here, Mr. Verma, was a 21-year-old second-year probationary teacher who was quickly made the scapegoat.
Counsel, how did you make out bad faith here? I mean, he's probationary, so he can be fired at any time for no reason unless there's bad faith.
Correct. He cannot be terminated unless there is bad faith. Here, there was no action taken by the DOE to terminate Mr. Verma's employment until after he made the complaint of corporal punishment, as he was mandated to do. It just
they had already been looking at him and evaluating him, and those evaluations kept getting progressively worse even before this.
As a first-year probationary employee, even without the one-on-one mentoring required by New York State, he achieved an overall effective rating. The DOE's argument pointing.
But would you agree, Counselor, that there was a decline in performance?
No, I would disagree. While the DOE points to specific categories throughout Mr. Verma.
And I want to say this, as my colleague said, this is in light of him being a probationary employee and you have to show bad faith. So you have, at least it appears that there seems to be some decline, plus at least 3 incidents of alleged misconduct. Isn't that sufficient?
Not in this instance. The 2 instances of misconduct that are alleged by the Department of Education were both refuted by Mr. Verma, and they also occurred in his first year. He was invited back after those incidents of misconduct by the same principal that now later terminates him. There was no disciplinary action taken or action taken towards terminating him until after Principal Dunn received an email from the superintendent that the victim's mother had raised the issue with the superintendent that the school had not taken sufficient action following the allegation of corporal punishment.
But Counsel, if you take the classroom observations in context, they run the course of 1 year because they begin in January of 2018 and they run in the second half of the school year, and then they run into the first half of the school year. And as Judge Singh was pointing out, the findings, the ratings, they didn't exactly improve. They went down to the point where his last rating was ineffective in 7 out of 11 categories.
Yes, Your Honor. The DOE has a mechanism in place, and that is an overall rating system, which takes into account each of those individual components, which may be rated ineffective or effective.
And then to that, besides that, to the classroom observations, you add the incidents that occurred.
Right. So in the second school year, so he was invited back by Principal Dunn for the second school.
So are you suggesting that what occurred in the first year can't be considered because he was invited back?
No, I'm not. But when you take into context the events that occur in the second school year and the timing of those events, that a
He's still in
disciplinary.
his probationary period during that time,
He
right?
is.
So it could have been, they didn't even need at that point whatever happened with this school, with the class evaluation. They could have used any one of the other things that came up with regard to the incidents. Is that right?
I apologize, Your Honor. When you look at the totality of the circumstances, there were 2 evaluations in that second school year, the 1 month that consisted of that second school year. One was by an independent evaluator who found him effective. She was not involved in this corporal punishment, reporting incident whatsoever. The individual, the principal, who was accused of not acting quickly enough, which resulted in a complaint to the superintendent, she's the individual that found him ineffective. They proceeded to schedule this informal 15-minute evaluation with 2 evaluators, which goes against the DOE's rules. And again,
Counsel, I'm sorry, are you speaking to the other instances of the verbal spat between the students where he puts them out in the hall, and then the other one where he doesn't let the school know that the father is, are you speaking to those 2 other instances?
I'm speaking to the 2 instances of performance evaluation in the second school year.
In the classroom?
In the classroom.
Right, and I'm asking you, couldn't any one of those other instances also have led to his removal since he was on probation?
Right, but the fact of the matter is that Principal Dunn had that opportunity in the first year, and she did not remove him from the classroom, and she invited him back.
I don't understand.
Thank you. You have some rebuttal. We'll get you on there. Okay, Ms. Gottlieb? No. Yes.
Yes.
Gottlieb.
Yes.
Okay.
Good afternoon, Anna Gottlieb for respondents. May it please the court. This court should affirm the dismissal of the Article 78 proceeding here. Petitioner failed to establish bad faith or any impermissible reason for the termination of his probationary employment.
But what about his position that it only came about when there was a report about corporal punishment? So he's being punished for reporting something that he felt he had to.
The temporal element can be easily explained here because there is a third finding of misconduct that actually arose from that reporting of the corporal incident, which was that Mr. Verma repeatedly spoke to the parent of the child involved in that incident against the explicit instructions of the principal.
So insubordination.
It's insubordination, exactly. And arguably that last third incident of misconduct is really the final straw in a series of disciplinary findings where he was insubordinate, where he failed to follow specific instructions.
What about your adversary's position that the fact that the teacher was invited back, that's an indicator that there were really not serious problems?
Sure. So that's really a non-factor here because the probationary employment period for teachers is statutorily 4 years. So it's not a probationary period that lasts 1 year. So the fact that he was invited back, I mean, the DOE was still feeling him out. He had these 2 incidents of misconduct. And then when the third one happened, that's the one that the school found to be egregious. Again, it's shown a pattern of insubordination. And throughout this time, since his first year, he did show, contrary to what my adversary argued, he did show declining standards, particularly in that first, he had a formal observation during his first year. And the formal observation.
But he'd never been, despite that, he had never been shown ineffective before. He had a number of different ones. He was found to be developing. He was found to be effective. But October is the first time where he's found to be ineffective, and in fact, in 7 categories. Until that time, the time right before, in fact, there were 9 developing and 2 effective. He's always developing. This is the first time where he's found to be ineffective, and it coincides with the very month that he reports the teacher, Ms. Sudel. So is that enough to establish the bad faith?
Absolutely not. And a few points there. He was rated developing more often consistently. So he started out with less developing ratings during his first evaluation. He had more developing ratings. And while he didn't cross over into the ineffective category until his second year of teaching, if you look carefully at the evaluations, they do show a common pattern of the same things that he just wasn't improving on. For instance, he didn't have clearly developed lesson plans. He often confused very basic topics in front of his students, and he just wasn't improving, which resulted in those ineffective ratings later. And the second point here is that even aside from his performance evaluations, there are 3 serious findings of misconduct against Mr. Verma. And those in conjunction with the declining standards here really do provide sufficient, more than sufficient evidence of good faith in this termination.
Thank you. Mr. Dugan?
Thank
you for 1 minute.
Quick points. I want to stress that, again, that the 2 allegations of misconduct in the first year did not warrant removal from the classroom or any disciplinary proceedings. A disciplinary proceeding was not brought against him until 7 minutes after the principal found out that the victim's mother had gone to the superintendent. She received an email from the superintendent that she'd been contacted by the victim's mother. Subsequently, 7 minutes later, Principal Dunn notified Mr. Verma that he was now subject to a disciplinary meeting for the alleged insubordination. In addition, this court has found, independent of all the other circumstances here, that the failure to provide a probationary teacher with one-on-one mentoring for the first school year is sufficient to prove bad faith, as well as not providing him the opportunity to improve his performance. Because as noted, this was his first ineffective evaluation.
But counselor, I'm sorry. There's 3 allegations of professional misconduct on top of that. So you seem to be just sort of picking and choosing what you wish to stress.
Right, and when the last one occurred under these circumstances, where it was only became a disciplinary issue right after the principal found out.
But there were two prior letters also, right?
And which were not deemed serious enough by that same principal to invite him back for that school year.
Okay.
Thank you. Thank you both.
Thank you.
Okay. Camera Supplies versus Geico.
Good afternoon, Your Honors. May it please the court, Stephan Belinfanti on behalf of the appellant. Your Honors, in this case, the appellate term issued a decision that was contrary to a plain reading of the regulation and the denial of claim form that the regulation references, contrary to clear precedent from this court. Multiple
Counsel, I have a question. So this is all about this form NF10. Does anyone have their mic on that's not speaking, other than the justices, of course? Okay. This is about this NF10 form, right?
Correct.
And the way it was, what it meant, and the way it was filled out. So my question is there anything in that form or anywhere in the form where it includes that failure to appear at an IME is a policy issue? Is there anything in the form that says that?
In their form, yes. Basically, so the argument that we have is that the form has to be read in its entirety. The form itself says that. It says, check off a box and explain your reasons in item number 33. It says that 3 times throughout the denial.
Yeah, but in this form,
yes,
numbers 3 through 8, right? Mm-hmm. I think of those are the ones that come under the title policy issues. Is there anything there that says failure to appear in the IME is a policy issue?
No, but it's not supposed to say that, because if you read those boxes, they're clearly categorical. For example, box number 4 says excluded under a policy, condition, or exclusion. There are over a dozen policies and exclusions in the no-fault regulations. None of them are listed there. That doesn't mean that if an insurance company asserts a policy, condition, or exclusion, which that would also include an IME no-show, because that is a policy condition which, if violated, excludes the party from coverage. But just
so
because
you're saying, so this form, you're saying, is not limited to the face of the form itself.
No, it's limited. No, it is limited to the face of the form, but after it's completed, and it has to take into account the defenses that the defendant put in there. I mean, the form is of no legal effect until it's filled out by the insurance company, right? Because the purpose of a denial.
Course. So once they fill it out, I'm saying.
Yes.
Once they fill it out, it's not simply limited to the words on the form, because there are aspects that you have to look beyond the form.
Correct. It's not limited to the pre-printed text on the form. Correct. Because the pre-printed text, the purpose of a denial of claim form, as this court has ruled several times, is to apprise the applicant of the reasons for its denial. A blank form doesn't do that. It's not until the insurance carrier fills out that form that the applicant now knows, okay, you're not paying me because of X, Y, and Z. And the regulation does not say limited to a policy issue in boxes 3 through 7. It says on the prescribed denial of claim form, because a prescribed denial of claim form is an entire form. I mean, the instructions in the denial of claim form make it clear that you cannot just take a snapshot of 4 boxes and not look at anything else, because the instructions.
So Counselor, am I correct that what your position is that just going to box 4, which refers to policy considerations,
yes,
that we should look to not just what's on the form, but also we should reference the mandatory personal injury protection endorsement and what those requirements are. Is that correct?
That is, yes, that's correct. It has to, because if go ahead.
So let me finish. So with respect to a no-show IME,
yes,
is that a condition?
It is a condition.
Under that endorsement.
It is a condition under that endorsement.
If it's a condition under that endorsement, your position is that box 4 applies, and that's the end of it. So tell me, what is it? Because there are a number of civil court cases, and now an appellate term case that limited to what's on the form. Why were those cases incorrectly decided?
Well, there are 2 published decisions on this exact issue which found opposite. There are only other 2 published decisions. That's Countrywide versus Ospina in the Supreme Court, and there's AEE versus Hereford in the civil court. I don't know what the factual underpinnings are of those decisions you're referencing, Your Honor. They're not published decisions, but I don't even know if here in Geico checked in those cases they checked off box 5, but they did here. They knew that. The thing is, I mean, Geico's arguing that a plain reading of the regulation, the denial claim form, shows that IME no-shows don't pertain to 4.6c. Yet they themselves checked off box 5 for their IME no-show case. Not only here, historically, we attached 10 years worth of denials where they took the same approach every single time. That's because
checking off box 5, you're saying, for a no-show IME?
Yes. If you look at
what exactly does box 5 mean?
Policy conditions violated. If a policy condition has been violated, then it triggers attorney fees under 4.6c. And I would just point out.
Yeah. Mm-hmm.
I'm sorry. I would just point out that is not just our opinion. The Department of Financial Services has issued opinions on this, 4 opinions on this issue, which were discounted by the appellate term. They issued an opinion in their first of all, they issued an opinion in 2004, I believe, where it said the inquiry that was submitted to the DFS was, what are the proper attorney's fees for a medical necessity case, not a coverage case? And the Department of Financial Services went through each of the attorney provisions, and they said, when it comes to the policy issue cases, those hourly fees apply when there is an exclusion under a policy exclusion or condition. A policy condition has been violated. That's their wording. It's nothing about late notice of claim. They have never issued an opinion saying it's limited to late notice of claim. Another opinion they issued was very recently in 2018. They issued a SAPA, which, yes, it pertained to a proposed regulation, but in that proposed regulation, they did not amend or even mention 4.6c. That proposed regulation was to expand it dealt specifically with IME and EUO no-show, and it would have allowed insurance carriers to void the assignment. And the DFS said, we don't think, this is in their regulatory impact statement, not in the text of the proposed regulation. We don't think this will have a detrimental impact upon the EIPs because attorney fees under 4.6C allow an hourly rate of $70 per hour and an appearance rate of $80 per hour for litigating that policy issue. They even use that term. Then there was an email. I understand this was an email, but from Lawrence Fuchsberg, who was the general counsel of the DFS. He issued many of those formal opinions, some of which are attached, where somebody wrote to him at the official email, where on the website it says submit legal inquiries here, saying, does the IME and IME no-show and EUO no-show defense, are they policy issues? On the policy issue, are they included as policy issues under the policy issue section of the denial? He wrote, yes, they are. I understand, the GEICO is raising some authentication issues, but this is their motion to vacate the judgment. The burden is upon them. And finally,
thank you.
Okay,
30 seconds. All right.
I think it's very important with this court precedence. This court has already ruled that by checking off a defense box on a denial of claim form, that means that an insurance company has asserted that defense. They did it not just in Global Liberty versus Therapeutics in 2017. They just issued such a decision in November, where they said that by checking off a defense box checking off a defense box, that asserts that defense. So how can GEICO here check off box number 5, have 9 appearances, trials, etc., and now after they lose a trial, say, you know what, we didn't really mean to check off box number 5, or it doesn't really apply here. They're stuck.
Thank you. Ms. Hirschfeld, you just—
Hi, good afternoon.
Just hang on. I just want to let you know, and you can remain that way if you want. We only see your eyes. That is it.
Oh.
I don't know if you want to push your computer back or tilt the screen a little bit, but no, now we see less. We only see your forehead now. So why don't you—
How's that? Is that any better, Your Honor?
Strangely enough, I see Ms. Hirschfeld's entire face.
Well, we see the most important part now, your eyes, nose, and mouth. Okay, I think that works. That works a little bit better. So,
I truly apologize, Your Honors. I'm having
really
terrible technical difficulties.
I just thought you might prefer us to see your whole face. That's the only reason I said it.
I'd like
to think impact or import of your argument.
I'd like to think I'm more effective when you can see my face.
It's okay. You here represent GEICO, and I have to ask you, what else does the term policy conditions or exclusions, as used in box 4, policy conditions or exclusions, what else does that mean if it doesn't refer to the if it doesn't refer to the policy conditions and exclusions in the MPIPE, which my colleague already referred to? I mean, don't you have to go out of that and look at the MPIPE?
Right. So, Your Honors, for box 4, the policy conditions and exclusions are a term of art here. And I don't think that there's any debate that the IME no-show would not be an exclusion under the policy, but it would be, if anything, arguably a policy condition violated. Here, the only logical box that the policy condition violated here in IME no-show could fall into would be box 5. And box 5 is specifically limited by its own terms.
Is it failure to show up at an IME a condition precedent? I mean, if you don't show up, you don't get coverage. Isn't that right? Isn't that a policy condition? You must show up.
Yes, it's a policy condition and it would be a violation. However, just because it's a policy condition violated does not mean that it's a policy condition violated as enumerated on the NF10.
Well, but I'm sorry. I don't understand that argument, because you have an endorsement here, and the endorsement specifically says that a condition for getting coverage is submitting to a IME, correct?
A condition for coverage is submitting to an IME, but it's not an exclusion.
Let's just take that one step further. As my colleague was saying then, box 4 specifically says policy considerations. So why is it unreasonable?
Policy conditions, policy conditions.
Excuse me, policy conditions. I can't read my own writing. Why isn't sufficient to look at box 4 and look at the endorsement and apply it that way?
Because box 4 applies to exclusions, whereas box 5 applies to policy conditions violated.
But policy, but the terms right there, I don't want to belabor the point, but it does say injured person excluded under policy conditions. So now, how do we know what a policy condition is? Don't we have to go to the MPIPE?
Right, we can go to.
And so when we go there, don't we see in the MPIPE that a policy condition is, or failure to show up in an IME is something that will eliminate? Isn't that a policy condition?
It's a policy condition, but it's not an exclusion, Your Honor. The exclusions
But it says or exclusion. It doesn't say a policy condition that is an exclusion. It says under policy conditions or exclusion. So if you're saying it's a policy condition, and this says it's a policy condition, and the MPIPE says it's a policy condition, why isn't number 4 the one?
It's definitely, because it's my understanding, Your Honors, that box number 4 is going to refer to exclusions, whereas box number 5 refers to policy conditions violated, which is what a failure to appear at an independent medical examination would be.
So essentially, you're saying that in box 4, we should just ignore the words policy in there. I mean, is that right?
No, there are.
And then just focus on exclusions?
There are, yeah, it's policy exclusions. It's policy. There are policy conditions that qualify as exclusions to coverage.
But it doesn't say that. It doesn't say that. I'm not sure where you get that, because the words that are there, and you're asking us to be very specific about these words in number 5. The words that are there say injured person excluded under policy conditions. The word policy is there and conditions, then that's a separate term. And then it says or exclusion. But looking at just the policy conditions, how do we get from where we are to where you are?
Right, so it's my position, Your Honors, that box number 4 is limited by box number 5, which is then limited by its own terms to subsections A and B.
And I'm sorry, can you walk me through the argument, because I'm not sure I understand it.
So, Your Honors, policy conditions violated under box 4 would be limited by, box 4 is limited by box 5. So a condition.
But how is it limited? I'm looking at it. Where is the limiting language that you're arguing is there?
It's our position that the exclusion under box number 4 means it applies as a term of art to policy exclusions rather than conditions, which are then addressed by box number 5.
So you're saying we are supposed to know, when looking at this form, that the word policy conditions in number 4 is defined by number 5, policy conditions A and B?
Yeah, so.
And then where is exclusion defined?
So exclusion isn't defined there, but it is a term of art, and it is defined in the statutory endorsement, in the prescribed PIP endorsement.
In the MPIPE.
So
you would agree then that
we go to the MPIPE for one thing, but not for the other thing.
Right. I'm sorry, Your Honor.
No, I said we go to the MPIPE for one thing, but not for another thing. How do we know this? How would we know that we're supposed to look for the definition for policy conditions below in number 5, but for exclusion, for that, we go to the MPIPE?
Right, because exclusions are a term of art. So those are listed specifically in the statutory endorsement, in the PIP statutory endorsement.
PIP. Oh, I had it wrong when I said pipe. Okay.
Wouldn't your
I don't have
argument
lingo.
Wouldn't your argument make more sense, counsel, if under 4, if there was no 5, and 4 would say injured person excluded under policy conditions or exclusions, and then go on to say policy conditions violated. But those seem to be separate.
Right, they are separate, but it is our position that it wouldn't be there if it didn't refer specifically to policy conditions violated.
Then shouldn't they have checked both boxes?
Perhaps, but it's our position, Your Honor, that the defendant's conduct in checking a box at a claim stage can't bring the defense that's not otherwise within the realm of 4.6C into 4.6C. And that's really why the statute itself talks about the prescribed PIP endorsement and not the manner or the way in which the defendant fills it out at the claim stage.
Okay, thank you. And I think we are back to your opposing counsel, Mr. Bellinfanti.
Yes, thank you. Your honors are exactly right about pointing out the PIP endorsement. The PIP endorsement, contrary to what counsel just mentioned, does list conditions and exclusions. It says, subject to the following conditions and exclusions, an eligible injured person is as follows. Underneath that, it has all the conditions. No action may lie against the carrier unless these conditions are met, one of which is an IME, one of which is an EO, etc. I don't have to belabor the point. Underneath that is exclusions. So box 4, when it says excluded under a policy condition or conditions or exclusions, it's clear. It's a policy condition or exclusion that excludes the party from coverage. And it's been ruled upon, not just by this department, but all the sister departments of the appellate division, that failure to appear to an IME voids coverage ab initio. So I don't understand.
Well, but the argument, counsel, I guess, from your adversary is that we have to read 4 and 5 together because I guess policy conditions in 4 is more specifically referenced in 5 when it says policy conditions violated. Is that correct?
That's not correct. There's no, you'd have to read language in there that doesn't exist. You'd have to make a leap, a huge leap. That's number 1. Number 2, even if you were to focus on box 5, it says policy conditions, plural. So their allegation that somehow it's only late notice of claim, it's undermined by the language.
But it says that. It says under 5A, it says no reasonable justification for giving late notice of claim. So it does.
I see that, but it doesn't mean that other policy conditions don't apply. There's nothing on the face of the denial that says that. And
so the issue is whether if we read 4 separately, then presumably your reading would go to the endorsement. We'd look to the endorsement as well under 4 with
not
policy.
Not only do you have to look at the endorsement for number 4, but if you look at every one of those categories, like eligible injured person is not the plaintiff, the patient is not an eligible injured person. That's somebody on a motorcycle, somebody involved in a felony. No, they're not listed there. They're not supposed to be listed there. They're listed in the endorsement, and that's why you have to read the denial in its entirety, because when the regulation says as enumerated on the prescribed denial of claim form, insurance carriers like Geico did here, like Geico did in all those other examples we gave, enumerates its defenses in item number 33, where it says place your defense with a high degree of specificity, attach extra sheets as needed. So those boxes they're clearly categorical. I mean, even if you look at your decision in Global Liberty, checking off the fee schedule box, fees not in accordance with the fee schedule, box number 18. Fee schedule is 500, 700 pages long. There's so many different types of fee schedule violations that could occur. But when an insurance company, they're not listed under box 18, but that doesn't mean they're not fee schedule defenses. So you can't read the denial as simply like a Scantron sheet, the way I guess the appellate term read it. You have to read it in its entirety. It's supposed to be filled out in its entirety. That's what. And the interesting thing is that's exactly what Geico did here. But now they're trying to distance themselves from their own denial, and it's just after trial, it should not be allowed.
Thank you both.
Thank you.
This was the last case of the afternoon. Thank you all. Court is adjourned.
Thank you.
Thank you.